that I don't know that this court has to make that finding, at least under Perry, whether or not there was a causal nexus. Let me just go back and say this, because this is something else that was pointed out in Perry. In my previous order, I did apply the 404B analysis in determining that evidence of the drug transaction could come in. I made that finding because that's important, because that was something that was also stated in Perry, that the court would have to apply a 404B analysis, and the court did that, as noted in my previous order. Now, with that said, and at the trial, during the trial and during her testimony, Ms. Harper testified that she had been at the Copacabana bar with the defendant, Daniel, and the person she identified as Poppy, and at some point they left the Copacabana, traveled to Midtown, and ultimately ended up at the Dogwood bar. She admitted in her trial testimony that she told Detective Beavis that Poppy had a substance that he was trying to sell. She also admitted in her trial testimony that she previously testified at the preliminary hearing that the reason they went to the Dogwood bar was for potential buyers of the drug that Poppy was trying to sell. And then, of course, yesterday she testified, about what she observed in terms of Mr. Moseley's activity with Poppy leaving the bar at some point. She assumed money to complete a and then continue between that clear and convincing, not beyond a reasonable doubt, clear and convincing evidence that Mr. Moseley and Poppy were engaged in a drug sale. Now, there is nothing that I can see under Perrier that requires the court to make a finding that there is a causal nexus between the two. So considering what the proof that was presented during the trial, that this jury heard Moseley was engaged language. That's the court's finding. All right.
Thank you.
Anything else? All right.
Oh, actually, Your Honor, there is one other thing.
I'm gonna like remove that question from yes, ma'am.
Your Honor, as you know, one of the state's material witnesses in this case was Sergio Alvarado. And I'm sorry?
I was just asking, had he been served with the warrant?
Oh, no. That's the basis for the request that I'm about to make. Your Honor, knowing that he would be a witness who would not willingly come to court, we started attempting to serve him with his subpoena well before the trial. Our investigator was able to make contact with him, was able to serve him, and was able to get him to appear in court on Monday. Based on some things that he was saying when he was here, and knowing that we weren't going to start proof until the following day, we became concerned, obviously, that he was not going to come back on Tuesday, and brought that to Your Honor's attention, who issued a material witness warrant. That warrant is still unserved. In our opening statement, we mentioned this witness, mentioned that he would testify. And now we're in a situation where we're unable to get him served with his material witness warrant. So the state's request is that in order to explain his absence, we could call our investigator to testify to what I've just told Your Honor. Investigator Randy Martin is here and ready to testify about the efforts that he made to get him here in the first place, the fact that he did get him to come here, and then the fact that he failed to show back up and the efforts that have been made to apprehend him.
Okay, Mr. Quillen?
Yeah, I would vehemently object to that. I mean, it's the state's responsibility to get him here.
Well, he was here and
Well,
I think his absence is not the state's, it was not the state's fault.
Not their fault,
Right.
but I know from a defense perspective, I'm very careful to avoid making statements in the opening statement that, I'm unsure about whether I can deliver on.
All right, let me think on that one, Jenna. How many witnesses are you calling this morning?
2, if Your Honor allows Investigator Martin.
You want to file those and give those to Dave so she'll know what she needs, and then this can go back and get this for that.
See if he would contact me. Just a couple hours after I spoke to Mr. Ingram, Mr. Alvarado did call me back. Said that he would meet me. We met at, I believe it was Highway 25 and 231 in Hartsville. I served the subpoena, told him it was imperative that he appear in court, that if he did fail to appear, the prosecution would ask for a material witness warrant. He assured me that he would be here. I gave him my phone number and asked him to call me when he arrived in court. He did, in fact, call me Monday morning and met me in the lobby. From there, I escorted him up to our victim witness room where he waited there. And it was my understanding that he was going to return Tuesday morning. However, he failed to return Tuesday morning. At that point, a material witness warrant was issued. Specialized investigation with Metro Police Department, they were contacted and they agreed to assist in the search for Mr. Alvarado. I went back to Hartsville, checked a few addresses there, spoke to his mother, and she had not seen him. She assumed he was in court, which was not correct. Specialized investigations discovered a location where they believed him to be, and it was an apartment complex in West Nashville. They didn't have a specific apartment number, so they canvassed the area, searched the area, couldn't locate him. I've texted his phone and I've called his phone. Every time I've called it, it appeared to be off.
Are people still trying to search for and find Mr. Alvarado?
Yes, ma'am. I reached out to Specialized Investigations yesterday and asked them if they would continue their search through today, and they agreed to that.
And has he been found?
No, ma'am.
If he had been found, what would have happened when the material witness warrant was served on him?
I spoke to the detective sergeant in charge, and he said that he would present him directly to this court.
And obviously that also has not happened.
No, ma'am, it has not.
Okay. And then one other question. Since you've had direct interaction with Mr. Alvarado, Can you testify about whether or not he has a tattoo on his face?
He does.
And where is that?
He has one over his eye, and he has one on his left cheek running down his face.
And Your Honor, that I asked that question just because it would, and also it corroborates JC Harper.
Feed store in Hartsville?
Well, I did not realize that in clothing store in Lafayette, Tennessee. So we in the feed stores in Lafayette. He didn't work at any of those. Western Clothing and Feed Store was actually just out of 231. But I don't know I don't know if they operate it, own it, or what their involvement is, but it's my understanding he and his mother both worked there.
Okay,
Yes,
and you've been to that place?
yes sir, I have.
Okay. All right, that's all I have. Thank you, Your Honor.
Okay, anything on your end? Now the question, General.
The question is whether or not that testimony
And you must saw me reach over and grab the rules of evidence as Ms. Tracy was testifying.
Your Honor, it's important. To be wondering why the state said he would be here and now he's not here. We said that in our opening statement. So, and it would answer the question as to why he now at this point is not here and why they are not hearing from him. And this is not, and it's a situation that the state did everything that we could legally do to obtain his presence here, and actually did get his presence here on Monday. And I will say, as an officer of the court, I participated in the conversation, or was aware it was here in the courtroom. As Your Honor knows, when Mr. Alvarado stood right here, was ordered by Your Honor to come back, and he refused to do it. He told Your Honor, after Your Honor asked him at least 2 times, you're going to come back. You are going to be here tomorrow. And he misled the court.
And I guess is it your position that under 401 that this is a fact that is of consequence?
Absolutely, Your Honor. Since we have put on proof about this person, everybody's been talking about this person. Detective Beavis testified that he was able to identify Poppy and the person who we see in the videos as Sergio Alvarado. We've made statements about him being here. We anticipated his testimony in this case.
All right, thank you, Mr. Quinn.
Well, there's no further testimony needed as to identification because Ms. J.C. Harper identified the photo from 2:04 a.m., identified Mr. Moseley, Daniel Sevilla, and I think
I don't think well, I guess the last question that she asked goes to that.
well, I mean,
Yeah.
that seems to be part of why they would like to have Mr. Martin testify.
Okay.
And, I mean, I just don't want to call attention to the fact
Well, just
Attention to what? Hold on. Attention to what fact?
that he's not here.
Well, and the state wants to call attention to the fact that he's not here.
In response to what he just said, if he was here, the jury would be able to see the tattoo on his face and be able to see that he's the same person in the video.
Yeah, I think that that's not big of an issue. I think what issue is fact that is the fact that he is something that the state needs to be able to address under 401. I think that is the ultimate issue.
Well,
I'm a little less concerned about the identity piece and more concerned about that. I don't know what Mr. Alvarado something related to the alleged drug transaction, I guess. I don't know. That point is something because previously, and that is whether or not Mr. Moseley was engaged in unlawful conduct. So I think that was the whole point of it. So I'm, like I said, I'm a little less concerned about identity. I'm just a lot more concerned about the fact and trying to determine whether or not Investigator Martin's testimony is something that is allowed under 401, 402, and 403.
And at this point, Your Honor, we still don't know whether it's a willful contempt, his absence. So.
Okay. Yes, I don't know. All right. As I look at 401, I think that it is the fact that it's of consequence based upon the proof that has been presented to this point. As I look at and who come in under 402, and I tried to look. I am looking at 403 and trying to determine whether or not there's anything about his testimony that under 403 that I don't allow Investigator Martin to testify. All right, now the dreadful question. Anything else?
No, thank you.
Okay. All right, line 'em up. Ask Debbie. Oh, I guess I should ask this, and it's probably, I don't know if you want to wait until after proof, Mr. Quillen, if the court should address the moment now or later. I can do it later.
Oh, okay.
I can do that later if you prefer.
I would prefer later.
Okay, that's fine.
All right.
Everything I was seated reflect that all the members the morning issues or anything with that. Is it cold here today? It was burning up yesterday. We can never get the temperature adjusted. I'm sorry. We'll see. They probably complained about it being so hot and turned it down. Y'all know I'm gonna ask the question. Y'all remember my rule yesterday. Did everybody comply with my rule? All right. I'm ready to call your name.
Yes, Your Honor, the state calls Randy Martin.
Randy Martin.
I know, but you don't, I mean, I know, they can't take 20 to 30 degrees. Your Honor, my understanding is that a short time ago, Mr. Martin started walking back towards the office, but now he's walking back here now. I apologize for the delay.
Like, what's the ETA?
Well, he couldn't have gotten too far because he was here just a moment ago. Maybe a couple of minutes.
Well, give us just 1 minute. For the charge, did you hear anything this morning?
his?
Would you please state your name?
Randy Martin, Martin.
Where do you work?
I'm an investigator with the District Attorney's Office in Nashville.
And what do you as an investigator typically do?
We, most of our time is trying to locate witnesses and serve subpoenas.
Okay, and bringing your attention to this particular case, were you asked to serve some subpoenas on several of the witnesses in this case?
Yes, ma'am, I was.
And was one of those witnesses Sergio Alvarado?
Yes.
Can you tell the jury the steps that you took in order to get him served with a subpoena?
Yes, ma'am. It began on March 15th. We were asked to attempt to locate him. I discovered that he was on probation. I contacted his probation officer, left a message with him. We had a phone number that we were attempting to call, but Mr. Alvarado was not answering that number. Once I made contact with the probation officer, I discovered the number we had was an accurate number. From there, we had an address, a home address, went to the home address. It was indeed his home. However, he was not there at the time. His mother was. I spoke to her, told her who we were and that we were looking for him to serve a subpoena. And it was imperative that he gave us a call. And if he refused to contact us, knowing that we were looking for him, we believed that a material witness warrant was going to be asked for.
And can you pause there and tell the jury what a material witness warrant is?
Yes, ma'am. Material witness warrant is used when we have witnesses that are avoiding being served subpoenas or have been served a subpoena and refuse to cooperate and appear in court. The court will issue that warrant. Once they're arrested, they are brought to court and they will testify at that point.
And after you told his mother that we would be seeking a material witness warrant if we were unable to have contact with him or have his subpoena served, what happened after that?
I left my name and my phone number with her and asked her to have Mr. Alvarado contact me. Then shortly after that, she gave us a place of business to look for him at, but she was vague in the business, said it was a feed store in Lafayette, Tennessee. So we drove from Hartsville to Lafayette. There were 3 feed stores that we stopped at, and he did not work at any of those. In the meantime, contacted me. I spoke to him and explained the same thing to him of our intention of obtaining the warrant. And he said he would try to contact Mr. Alvarado and have him call me. Shortly after I spoke to Mr. Ingram, Mr. Alvarado did call. He expressed his concerns about testifying, said he did not want to testify, but he would meet me the next day. We met at Highway 25 and Highway 231 near Hartsville. Served the subpoena, and I've got a copy of the subpoena that I served. And I explained to him that this was a serious matter and that it was my understanding that we were going to ask for a material witness warrant if he failed to appear, and this may possibly violate his probation.
And when did you tell him he was supposed to appear?
I told him he was supposed to appear on Monday, March 28th.
And did he actually appear?
He did. I left him my cell phone number and asked him to contact me when he arrived at the courthouse. Monday morning, approximately 8:15, 8:30, he called and said he was here. I met him in the lobby and escorted him to our victim witness room where he remained until that afternoon.
And as you know, we did not start proof until Tuesday.
Correct.
Was he told to come back on Tuesday?
Yes, ma'am, he was, and he was warned that if he failed to appear on Tuesday morning, that a warrant would in fact be issued for his arrest. He
Did
not.
then after he didn't appear, what efforts did you make to get him to appear?
I attempted to call him several times. His phone had been turned off. I texted him.
And let me pause there. Was there a material witness warrant issued?
Yes, ma'am, the warrant was issued.
Okay. And then you attempted to call him.
Yes, ma'am. It was going straight to voicemail, so it appeared that his phone had been shut off. Specialized investigations with Metro Police Department was contacted, and they agreed to assist us in that manner. They began searching for him, and late Tuesday night, I got a phone call saying that they had located an area that they believed Mr. Alvarado was located. They searched that area but did not find him.
And did efforts to continue searching for him, have they gone on continuously up until this very moment?
They're continuing at this moment. Yes, ma'am.
And obviously at this point, they're unable to serve that material witness warrant.
Yes, ma'am, they have.
Did you have an opportunity? You testified that you actually served the subpoena to him, that you made contact with him when he came to court on Monday. Were you able to observe whether or not he had any tattoos?
He did. He had facial tattoos. He had a tattoo over his eye, and he had a tattoo that ran down the side of his face.
Your Honor, those are my questions.
Okay, Mr. Floyd?
Your Honor.
Okay, thank you. Investigator Martin. Okay, General, are you ready to call your next witness?
Yes, Your Honor. The state's next witness is Alva Bethurum.
Alva Bethurum?
Actually,
Bethurum? Alva Bethurum?
Sir, if you would, raise your right hand. Do you solemnly swear or affirm that the testimony you give is the truth, the whole truth, and nothing but the truth, so help you God?
Could you please state your full name for the record?
Alva Jefferson Bethurum Jr.
And could you please spell your first name for the court reporter?
ALVA.
And if you could actually lean in a little bit closer to the microphone just to make sure everybody can hear you.
Is this better? A little
Yeah,
bit better?
maybe a little bit more.
Okay.
Okay,
How about
that's
now?
good. Can you spell your last name for the court reporter, Mr. Bethurum?
Bethurum.
And Mr. Bethurum, do you go by AJ?
I do.
How old are you?
I'm 23 years old.
And where are you from?
Franklin, Tennessee.
Where did you go to school?
Battleground Academy.
And when did you start at BGA?
I started there in kindergarten.
Where did you go after you graduated from BGA?
I attended the University of Tennessee, Knoxville.
And did you graduate from that university?
Yes, I graduated with a degree in biochem.
When did you graduate?
May of 2020.
What are you currently doing?
I'm currently enrolled at ETSU. I'm in med school, getting an MD degree, and also getting a master's of public health.
And can you describe, how tall are you?
I'm 6'2".
How much do you currently weigh?
I'm 180 pounds.
And back in December of 2019, how much did you weigh?
Roughly 155 pounds.
So you were smaller then than you are currently here today. Is that right?
Very much so.
Can you describe your high school friends and your relationship with them?
It was awesome. I mean, a lot of us had known each other since kindergarten. We had a big group that stayed at BGA all the way through. And then, everyone who was added to that class throughout our time there, I mean, we just welcomed them with open arms, and we were, super close, super tight.
Are you still close with them today?
Yes, ma'am.
I want to ask you about Clay Beathard. When did you meet him?
I met Clay in 8th grade.
And can you describe him?
Just a godly individual, all around, just funny guy, fun to be around, a true athlete. I mean, the guy had it all. He was awesome.
And did you ever know Clay to be the type of person to pick a fight
No,
or kind of egg on a fight even?
no.
And what about Paul Trapeni? Can you describe him?
Paul is probably the funniest person I've ever met. He had this kind of laughable, not kind of class clown aspect to him where he would just make everyone laugh. But when you needed him and, you needed to talk about something, he would be the most genuine, honest, caring person he could be with you.
So he's a class clown, but he also had a kind of serious side to him as well.
Yes.
And can you describe your friendship with Sam Folks?
Me and Sam are super good friends. I met him 8th grade as well, and we stayed friends throughout high school and college. And when I was in Knoxville, he would come up and visit, hang out on the weekends sometime. And he was in Martin. I'd sometimes be in Martin over winter break, waterfowl hunting, and hang out with him then. So we've stayed close throughout.
And is he the type of person that would pick a fight?
No.
And can you describe your friendship with Wilson McCullough?
About the same as the last two. Wilson and I have been friends since roughly 8th grade as well. Wilson's an awesome guy. I mean, we're super close and have remained close throughout the past 9 years. We're great friends.
And is he the type of person to pick a fight?
No.
And can you describe, what did you know about his relationship with Emma Yoder?
So Emma Yoder and Wilson kind of had a friendly high school relationship, boyfriend and girlfriend, that kind of somewhat dissolved after high school. I'm not sure of all the details on it, but they were not currently dating at the time of everything that happened.
But were they still friends?
Very much so.
And kind of drawing your attention specifically to the night that all of this happened, can you describe that night? What were you doing prior to going to the McCullough's house?
I believe I'd just gotten back from West Tennessee. I'd been waterfowl hunting, came back for this winter, and I wanted to catch up with them. So I probably got home and took a nap and then headed over to McCullough's house.
And can you describe what you doing?
Each other. So we were just catching up. Walking and just.
And remember that at some point you left.
Yes.
And where did you guys go?
We went to the Midtown area of Nashville.
Had you went to? Do you have any idea how long you guys stayed there?
I remember we went there and walked in and found out that the other group of friends that we were trying to meet up with were actually at Dogwood. So I bought here, and I was about a third of the way through it, maybe halfway through it when we left to leave to the dog attendants.
left Kung Far, is that right?
Correct.
And can you describe the mood and atmosphere there?
About the same. As we caught up and we're having a good time with all of the friends from our class, it was the same with the group of people we met up with, because they were actually a group of students that graduated a year prior to us. So we were talking to them about the same topics, how they were doing, where they were, things like that.
And did anything happen inside the bar that you thought was unusual or anything?
Just a good time, friends.
And at some point, y'all did leave the bar, is that right?
Correct.
Do you remember anything happening on the way out of the bar that concerned you?
No.
And I want to ask you specifically about what you remember after this date of December 2018.
Mhm.
When you looked back on it, what did you remember happening when you left the Dogwood Bar?
I remembered walking out, and as I got to the sidewalk to the left, and then I was turned to fight. The fight moved across the street, and in the process, it looked like it was not de-escalated. And then I became involved in the scenario, and the events transpired.
Did you have a perfectly clear memory of everything that happened?
Mostly. There were some very minor details that the video helped to clear up, but it was just so chaotic that initially my memory had to have some gaps filled in, because I think after an event like that, you kind of, for the most part, my memory.
Can you describe what happened to you personally, when you would
Bar that night, this event was occurring, this fight, and I saw that it was moving across the street. It was not dispersing. It looked very aggressive, and I went to the defense and tried to break it up or defend my friends. I confronted an individual, and then after confronting that individual, I was stabbed multiple times.
Where were you stabbed?
I was stabbed right under my left eye. And
was it just the skin under your eye, or where exactly were you stabbed?
No, I was stabbed. That was the entry point. The knife actually through the back of my eye, and actually through the posterior wall of my orbit. And I actually had an air pocket in my brain because it went through my skull. Yeah.
So the knife went into the side of your face.
Yes.
And then you said you were also stabbed in your elbow.
Yes.
And can you describe that?
I was stabbed approximately right here. The knife came in at about this angle and actually went into the joint capsule, probably about 1.5 inches or 2 inches into my arm.
And can you describe that moment of, you said that you went to kind of break up the fight, but also defend your friends.
Yes.
What was it that you saw happen that you felt like your friends needed defending?
Well, when I initially saw this fight occurring, in my mind, I figured this was just, a simple disagreement, some guys pushing and shoving, and it would dissolve as it just moved away a little bit. But as it crossed the street, there were still punches being thrown. It was not de-escalating. and a female got pushed over in the process, shoved to the ground. And that's, in my mind, that is not a simple conflict anymore. That's malice, and my friends are in danger. You know, they're getting shoved to the ground, they're getting punched, and this is obviously not just going to simply dissolve.
Over there, what did you do?
I walked up to an individual who was a little bit shorter than me, maybe by 2 inches. And I put my hands out, confronted him, and I'm not sure what was exchanged. Not that individual, someone else reached around and stabbed me. I never saw the knife, never saw anything. And I actually originally thought I'd just been punched.
What direction did that, what ultimately you know is a stab that you thought was a punch, what direction did that come from?
That was from my left side.
And that initial contact, is that the contact with your eye?
Yes.
And at that moment, can you describe what happens with your left eye?
So my vision immediately went out in that eye. And I knew in my head, I'm incapacitated, like I can no longer participate in trying to get this fight to break up. I'm done. So I immediately started moving away. I thought that originally, I know some boxers, you know, they get punched in the face and they have a retinal detachment. I thought that's maybe that would have been what happened to me. So I held my hand over my eye and just kind of moved away from the situation.
Do you remember anything happening to your left elbow?
No.
And at what point, I guess you said that you did not know that you had been stabbed. You thought you had been punched and there was something wrong with your eye.
Correct.
At what more than just a...
It was at least a minute and a half later. After round, and Patrick Wells came over and helped me up. And
Which, when you say you went to the ground, did you go to the ground or did you get pushed to the ground?
originally, this is one of the minor details I was talking about earlier. Originally, I thought I had gone to the ground voluntarily, but I was walking away, and on the video you can see I have my hand over my eye, and this a couple people come over and shove into me, and I went to the ground after that.
And that's something that you initially did not remember.
Correct.
And so at some point after this event, did you talk to a detective?
Yes.
And then of the video.
Yes.
And is that how you're able to kind of differentiate between what you initially, when the detective showed it to you?
No.
Just a small portion of it, is that right?
Correct.
So kind of going back to the actual incident, you said that you know now that you were knocked to the ground.
When I got up, Patrick Wells was there, and we were kind of just trying to see what was going on. I was obviously dazed and maybe a little bit in shock. So we were trying to talk through that.
And when did you realize that something had happened to your friends?
In that conversation with Patrick, I'm not sure who it was, but I very clearly remember someone saying Clay's been stabbed. See Clay being stabbed.
Did you see Paul being stabbed?
I did not.
And you've already testified that you did not see yourself get stabbed.
No.
Did you ever see a weapon?
No.
And can you describe kind of your injury? You've described that the actual stabbing of your injury, but can you describe your eye injury and what you went through?
Sure. So after this event, I went to Vanderbilt University Medical Center. The next day, I underwent kind of a damage control operation. And roughly 2 weeks or a week after that, I had another operation to repair my retina. Throughout the course of the next few months, I actually was starting to gain back a small portion of vision kind of in my periphery. But at that same time, I had a cataract form due to the trauma to my eye. So in July of 2020, I underwent cataract surgery to remove the lens. And upon doing so, they were able to get another look at my retina in the back of my eye. And throughout the course of those few months, it had actually scarred down, and I don't have any vision out of it now.
And at that time, did you have some vision?
At that point, that was between the second and third but as the cataract grew in, they weren't able to get a clear picture. And they noticed that over those couple months, they were down. No vision.
And can you describe what, if any, pain that either of your two injuries caused you?
The elbow injury I didn't feel it at first. The injury itself, I didn't know I had until minutes after it actually happened. But the treatment for it was pretty excruciating. Once I got to the hospital, since the knife had gone into the joint capsule, they had to insert a large bore needle into the other side of the joint capsule to irrigate it and flush it out to prevent any infection. And that was extremely painful. Three multiple big in clinic procedure. It's been physically and emotionally painful for sure.
Some of the video used in exhibit number 11. And have you had that today to view some of, and that you've reviewed? I am going to show you what is exhibit number 11 and folder 11. Mr. Bethurum, do you see yourself in this image?
I do.
Would you touch the screen and just identify where you are at?
Did that work on y'all's end?
Yes.
Okay.
Is it not on yours?
No, it's good.
And if you can just generally describe what is going on right now.
It looks like David Bates and I are just standing next to each other, chatting about something. I'm not sure. It just looks like we're having a good time.
Can you describe if you see yourself and what's going on now?
Yes. It seems like in that scene, it was Patrick, Paul, and I just kind of joking around, messing with each other like we always had. All friendly. I mean, you can tell that all three of us are laughing right there, just messing around.
Mr. Bethurum, you testified that you were having you have too much alcohol to where that you couldn't remember anything that happened?
No,
And any of the issues with your memory, is that related to alcohol or related to something else?
it's not related to alcohol.
And Mr. Bethurum, did you know Michael Moseley on December 21st, 2019?
No.
Since then, have you learned who he is?
Yes.
Do you remember ever seeing that night with friends? And specifically, when you saw at someone, when you were out, sure about that.
I'm
I'm going to fast forward to this point, which is 246:50. Mr. Bethurum, or anything in the bar?
yes.
And do you remember anything happening at the top of the stairs that concerned you?
No, it just seemed like, we were all waiting our turn to go down the stairs. There were a lot of people trying to go down the stairs at the time.
And I'm going to show you Exhibit 11, Folder 10. I'm going to skip ahead to 247:20. Again, Mr. Bethurum, do you remember leaving? Any that concerned you?
No.
And I'm going to show you Exhibit 11, Folder 7. And if you could describe what you see in this video, as well as if you could describe where you are and what you are doing.
Sure, that's me walking out. I'm in the circle right now. Paul slaps the sign. Oh, didn't mean to touch it right there. And that's me kind of walking over behind him, just waiting for our Uber. Here, and I turn around and see what's going on. You can see me watching. Punches are still being, trying to keep people out of it. And that's when there's a female shoved to the ground. The punch is still being thrown. I go to confess, and I'm on the ground at this point.
And is that the part where you didn't remember actually getting knocked to the ground?
Correct.
Mr. Bethurum, I'm showing you Exhibit 11, Folder 7. Your Honor, I would like to pause this video during this portion of his testimony. Would it be all right if I sat to do that? Yes. Touch the screen. And is this the point that you went to confront the people about your phone?
Yes.
And if you can press the clear button, it will remove that arrow. And if you could touch the screen to show where you are. This interaction prior to you being struck.
Yes.
And can you describe what you see happening here?
I was just struck in the face.
And can you describe what just happened there?
Yes, I was walking away with my hand over my face, and one of the people in the group that just ran over shouldered me to the ground.
And that is what you described as something that you did not remember happening right after, is that right?
Correct.
And who is that that is standing there with you? Which at some point, Mr. Bethurum, do you go across the street?
Yes.
You go across the street.
As soon as I heard Clay's him laying there, and then I assessed what was going on, tried to locate where he was stabbed and see if I could help out in any way. After about, I would say, 30 seconds of doing so, one of the bouncers from the bar that was actually trying to help Clay out as well, he pushed me in the chest. He's like, "Bro, you've been stabbed too." And I kind of just didn't pay attention to it. And then he kind of forcefully picked me up. He was like, "No, you're bleeding a lot."
Did you even realize that you were bleeding at that time?
No.
And what did he do?
He handed me a clean rag from inside the bar, and I put it over my eye, and he kind of escorted me away from where Clay was laying and to this little wall in front of the bar and sat me down there.
When did you realize that your elbow was injured?
Not until the paramedics were about to put me in an ambulance.
Witness be handed 5 photographs which have been shown to defense counsel. and they have been pre-marked A through E. Mr. Bethurum, if you could look at those photographs and let me know if you recognize those.
Yes.
And are those photographs that were taken of you and your injuries on that December 21st of 2019?
Yes.
All right, this time I would ask that those photographs be introduced with the next numbered exhibit. 60.
Yes.
Just for the record, is it 60?
It is.
Okay, 68 through. Mr. Bethurum, this is Exhibit 60A. Could you describe what is shown here?
That's
And can you just describe for the record your left eye?
yes. That's some sort of protective cover that the people at the hospital had put over it. There's someone there trying to address the wounds, maybe clean some blood up. Is there anything else?
This is 60B. Can you just,
Of the stab wound to my arm, wrapped.
and this is 60C. Can you describe what is shown here?
Yes, that's an image of the stab wound to my left arm uncovered.
And 60D, can you describe what is shown here?
Yes, that's an uncovered image of the stab wound to my left eye.
And that's the exterior injury to your eye.
Correct.
And 60E.
That's someone assessing the same injury in the previous image.
And that's the stab wound to your left eye. Is that correct?
Correct.
I can have just one moment. Thank you, Mr. Bethurum. I don't have any other questions.
Thank you.
Hi, Mr. Bethurum. You testified at the preliminary hearing in January of 2020. You remember that?
Yes, sir.
And I believe then you said that you were 6'3". Is 6'2" more accurate?
6'2" is accurate. Oftentimes with shoes on, it's 6'3".
And with that, how much taller than
2 to 3 inches.
would you have been as much as 4 inches taller than Clayton Beathard? Relationship with Paul Trapeni since kindergarten?
Yeah.
Very close with 8 drinks?
No, I believe it was less than that because some of them were.
Nurse Brianna Mitchell at Vanderbilt that you had consumed 8 drinks?
I do not recall that conversation. Possibly so.
Okay, if I may pass you a copy of this, you can refresh.
Sure.
And it's actually the 4th page of the documents that I gave you, which is what I received, but I think it says page 11 down on the
that's what.
So are you saying you had less than 8 drinks?
The McCulloughs had half of one beer at okay.
And it may be that I need to pass this to the, you see it. Out of the restroom area?
Yes.
And I'm gonna put a little AB on your stomach area just to note that that's you. And you send the picture, men?
Yes.
Okay. Now, do you recognize either of those men as the one you hit?
The one with the puffy jacket kind of resembles the guy, but I can't be completely sure.
Okay. He would be considerably taller than that man, correct?
One might say.
That is a- And this is we're just looking. I just want to, sometimes it's easier to use the still photographs. And are right under you sign, can you see it?
I'm right in at the top of the image in between the two glares of the light. Yes.
Okay, and that's Miss Oliver behind you, or, well, I guess somewhat to the left of you.
I would assume so.
Okay, I'm gonna write a little AB up here to denote you. Let me know if I'm doing it wrong. And at some point, I believe you used the word beeline, you make a beeline across the street.
I walked directly across the street.
All right. And if you can't pick yourself out, I understand certainly.
Okay.
This is you in that, when you're doing the beeline.
That's me walking. Yes, sir.
Okay. Writing another AB to denote you. Let's see what and a few frames later. See yourself right here?
I'm not really sure in this image.
Okay.
The colors are a little different and off.
Oh, that's a little better. Yeah. Okay.
I can't tell for sure.
Okay. Can you recognize this as Miss Fowler?
No.
Okay. Now this is probably even more difficult, I'm guessing.
Yes, sir.
248-43, is this Clayton Beathard in the white?
Like the previous image, I can't be for sure. I'd have to maybe see it up close or.
All right. Well, that's fine. And here's for a different camera angle, also from 248-43. Now, can you identify Clayton Beathard? And it's pretty dark, but can you see yourself there?
I can't distinguish myself for certain. It seems like that would be me
Okay. All right.
based on the.
We'll just leave
Based on
that.
where everyone
All
is.
of this is our little collective exhibit of 3 photos.
And on the Sunday, December 29, 2019, you were interviewed out at Battleground Academy with Detective Beavis and Detective Joyce. Do you remember that?
Yes, sir.
Okay. And I think at that time, you used the line, I made a beeline towards this person you thought had harmed or wronged Ms. Favre.
I may have said that.
Okay. And I'm going to show you a video of that. It's defendant ID number 9. Video, and then you stop and point. Okay, recognize all that?
Yes, I would. I don't know if I was pointing or my left arm in that image was down to the side like this. It wasn't like I was sitting there pointing. I think it was more of a what's going on type gesture.
Okay, all right. We'll offer that as our next numbered exhibit. Defendant EFT ID 9. And after, of course, that video ends at 248:43, and at that point, you veer off to the right. Do you remember that?
Yes, sir.
Give us a minute, Mr. Plum.
I'm sorry?
Give us a second. We've got.
Oh, yeah, I'll call it. You ready to throw a punch?
The image went out. Yeah, there it is. I'm not sure if I should picture if I for sure that's me.
Okay, all right.
Now, you get hit from the back, correct?
It came from my left side, whether it was.
Now, I mean, since then, have you seen a video where a couple people crash into your back?
Yes.
Okay. And when you go down, you think, holy crap, we've just lost this fight.
Well, I was out of this. Like, there's no can contribute to trying to diffuse this anymore. So that's why I stayed on the ground.
Well, I mean, when you were talking to Detective Beavis on December 29th, that's what you said, I believe, and I can play you that audio.
Sure, I'll listen to that.
Okay.
No, I already have.
Oh, you have listened to it. So
Yes,
you
sir.
did say, holy crap, we've just lost this fight.
Yes.
Or you think that?
Mhm.
Okay.
That's going through my head when I'm on the ground.
All right. And part of the reason you think that is you're really surprised that you're losing this fight.
I wouldn't say that. I mean, I just got hit really hard. I was like, wow, if this person's hitting this hard to take my vision out in one punch, you know, that's a formidable opponent.
You expected to win that fight, didn't you?
There was no winners. I wouldn't call.
At that preliminary hearing in January 2020, I believe you said you went to the defense of Thoby Farber. Is that correct?
Yes, and she was involved in the whole group of events.
When you hit who hit?
Because it's where I saw her go to the ground.
You walked right past Thoby Farber on your way towards hitting somebody. Is that correct?
Yes.
Okay. And you did not go to help out Thoby Farber, correct?
That's correct.
And Patrick Wells went to her aid. Is that correct?
I'm not sure of that.
And at the time you hit, whoever you hit, Ms. Farber was a good 20 feet away from.
I would say 10, maybe 7 or 8.
Are you saying she was in the same lane of Division Street that you were?
No.
But at that time, she was under no threat from whoever you hit. Correct?
No, people were still in threat.
Well, your friends were actually advancing on Mr. Moseley.
I saw the situation.
That went to the asphalt, correct?
I was fairly certain that it was, but I was not positive.
Okay. And you person you were going to hit had pushed or shoved Ms. Farber. Is that correct?
And those individuals involved who were not my friends. I knew that the individuals involved that were not my friends had shoved a female on the ground and were actively involved in punching my friends as well. And so that's when I decided to become involved, because it was apparent that the situation would not defuse.
Well, back in that January 2020 hearing, an attorney named Justin Johnson asked you if you actually saw this person hit or shove Ms. Farber, correct? And he asked you, did you actually see it, or was it just in the rush of everything? Accurately restating what happened at that hearing?
Not certain about that exact line, but if it's on the record, then I believe you.
Let's play it just to make sure that we're going to play Defendant ID 20.
This is audio only.
There was a female that hit the ground, correct?
Yes, sir.
Was this after the fight had started?
Yes, sir.
did you see anybody hit her or push her, or was it in the rush of everything? It was a,
The rush of everything, correct?
Yes, sir.
Okay, we'll offer that as our next exhibit. And also, speaking of that December 29 interview with Detective Beavis, you stated that it was from the back, I got hit in the face. Is that correct?
Yes.
Your Honor, if I may have just Mr. Bethurum, would it be more accurate to say that when you went to punch whoever you punched, that you were more interested in punishing that person than defending another person?
That's false.
All right, thank you.
Anything to reiterate?
Just briefly, Your Honor. Mr. Bethurum, the first time that you are struck, that is the strike to your left eye. Is that correct?
Correct.
And that is the stab to your left eye.
Correct.
And you lose vision immediately.
Correct.
And you know that you were struck again because your left elbow is injured, but you don't actually remember that part happening.
No.
Thank you.
One more.
Mr. Bethurum, after you say you were struck, you actually advanced another 2 or 3 steps towards the sidewalk. Is that correct?
Yes.
Thank you.
Anything to reiterate?
No, Your Honor.
All right, thank you. So watch your step as you step
Yes,
down.
ma'am.
Please
Thank
take your
you.
time. All right. All right, gentlemen.
Your Honor, that is the state's proof. In this case, we do not have any other witnesses to call.
Okay. Ladies and gentlemen, this state has rested, but there are some issues that the court needs to address. So you all can step down and go to the jury room. My rule. Okay.
All right.
Okay, we may all be seated. Mr. Quillen, the state has rested.
I was hoping we could have a road trip
Oh,
and then I'd have some chance to discuss.
okay. All right, we'll take a short break.
All right.
Yes.
Hello everybody, welcome to Potentially Criminal. My name's Sean Martin. I'm a defense attorney in Cleveland, Ohio. And on this channel we cover many topics in criminal law. Anything that's popped up in the news, general legal education, or if you're watching this, a trial. We'll cover it, we'll talk about it. Generally speaking, I let the trial run its course, and then when there's breaks or recesses, I like to give my commentary and thoughts on what's going on.
What are you, retarded?
In addition to the trial streams and videos that I produce, I also do a weekly stream every Thursday night at 9:30. In that stream, we cover topics that have occurred during the week and anything else people may bring up on their own. Now, the reason why you're watching this instead of listening to me talk to you in person is I am a full-time attorney. So if you're watching this, I'm probably in court. So if you like what you see here, please give me a like, please give me a subscribe. I would greatly appreciate it. And until next time, just because you did it doesn't mean you're guilty.
inferences from that choice that you make. Do you understand that? In other words, they cannot hold it against you, and I will instruct them. There's been a jury charge, and I haven't read it, explain it. To them. If you, as I mentioned, you have the right to testify. And if you wish to exercise that right, no one can prevent you from testifying. Do you understand that?
Yes, ma'am.
Okay. Without telling me the content of your discussions, have you consulted with Mr. Quillen about, I guess, the pros and the cons of testifying?
Yes, ma'am.
And I guess what the advantages and disadvantages, you talked about all of that?
Yes, ma'am.
All right. After talking to your lawyer and after careful consideration of your constitutional rights as it relates to testifying, what is your choice?
I waive my right.
Mr. Quillen?
Nothing, Your Honor.
All right. All right. You all should have gotten, I think each, is she making me a copy? I wanted to make sure, Mr. Quillen, if you want to look over that and make sure that the lesser included that you listed are you calling any witnesses at all?
No, Your Honor.
Okay. Mr. Quillen? Well, I guess send them right back out.
All right.
I mean, if you need some time, I'll give you
15 minutes.
about 15 minutes. That's a long time. How long is your closing argument? What are my rules? I think I have rules on my closing argument. Well, I figured that. What are you thinking about? What about 30, 40 minutes, 45, 50?
Yes, not longer than 45.
Apparently, I wrote a rule some time ago, and I'm not even complying myself. Closing argument should last no longer than 20 minutes per side. Oh, misdemeanor cases, 45 minutes in felony cases. But I give a little bit. All right. So I'm going to give Mr. Quillen's argument. All right. Because we're going to, when I bring the jury back in, we're going to keep going. Because I think the only thing that I need to do in the jury's presence is, because you've already closed your proof, we've already done the moment oath, ask if you have any, do you have any JOAs?
JOA?
Judgment of acquittal motions, or
I guess we can do it on the record here.
Your Honor, I'd move for a judgment of acquittal on the first 3 counts. We have a case where nobody identifies seeing a weapon. We have a knife that was recovered on which no serology evidence was recovered. And especially with regard to Mr. Trapeni, it's very difficult to see what goes on in that video. And except for Detective Beavis, I don't know of any witness who said or even suggested that Mr. Moseley stabbed Mr. Beathard. And also with regard to Mr. Bethurum, Mr. Bethurum's testimony was that he was stabbed out in the street, but we see on the video that he walks forward about 3 or 4 feet and then I think throws a punch. And a few seconds after that, then the people hit him from the back. So I think the evidence on Mr. Bethurum is also weak. So Thank you.
Okay, thank you. Did the state care to respond?
Your Honor, just that the state has at a minimum proved the identity of the defendant. Mr. Quillen had people pointing out who Michael Moseley was on the video, and you can clearly see in the video him stab both of our victims. We've proven at least put on.
This stage of the trial, looking at the proof in light favorable to the state, which is the burden at this stage of the trial, the court finds that at least a prima facie case has been made for the jury, for the case to be presented to the jury. So I'll deny the motion, and you need about 10 minutes. Okay, 15. Y'all make sure y'all look good with the jury instruction, because when I come, we're gonna keep going. Y'all have any before I bring the jury in, y'all let me know.
Let's go. Court stands at 15-minute recess. they see. I'll just say. Only like the first minute has. I think that was loose, that machine loose, then. Yeah. I didn't know. I didn't know. But you're gonna tell him. And you're not gonna be scared. No, it's just. Yeah, I was, we're gonna use about 3.5 minutes. First minute.
She doesn't want this off
won't be.
Remain seated. Come to order, please. Or next session.
Okay. Ms. Busey, after the closing arguments, I'm gonna go straight into the charge. Now, if I need to just kind of, stop for a few minutes, I don't know if you're gonna have I may want to explain to them what the charge is. This one probably take me in the neighborhood of about 35 minutes to read. I can pause for a few minutes if they want to, if some of them want to be excused. But I just so that they know, but I need to focus on the charge, Yeah. If you just want to explain that to them. All right. All right. Are we ready?
Yes, sir.
Mr. Quillen? Now, Mr. Quillen, I will ask, because this is what I'm supposed to do. When I bring the jury back in, I'm going to remind them that the state is closed, and I'll ask if there's any proof on behalf of the defendant.
Thank you. Yes.
You ready to pull the alternates? Okay.
Unless somebody helps.
Yes, he probably did. The judge still does it the old fashioned way.
Yeah, I think that is that.
Do any of the other judges do it the old fashioned way, or is he the only one?
He's the only one that does it.
He sits at 12 and then sits and then identifies.
Yeah, but the short thought.
All rise.
Okay, we may all be seated. Let the record reflect that all the members of the jury who are hearing this trial are present in the courtroom after that break. Just before the break, the state rested its proof. Is there any proof on behalf of Mr. Moseley?
No proof, Your Honor.
Okay, is the state ready to proceed with your closing argument?
Yes, Your Honor.
Ladies and gentlemen, just as I mentioned to you during jury selection at the very beginning of the trial, the parties are presented an opportunity to present an opening statement with your at the beginning of trial and closing argument. Now, these arguments are just their perspective of the proof. It is not proof for you to consider. It's their perspective of the proof that you've heard in the trial. Okay, gentlemen.
Only one person knew that people were going to die that night of December 21st, 2019. Only one person knew that Michael Moseley had a knife. One person. You heard from the 8 people that survived that night. Each and every one of them testified this week. And they told you they never saw a knife. They didn't see their friends get stabbed. None of them saw AJ Bethurum get stabbed. None of them saw Clayton Beathard get stabbed. None of them saw Paul Trapeni get stabbed twice. They didn't see a knife. You heard from 15 to 20 people that were out on Division Street that early morning. And every single one of them said it was pushing, it was shoving, it was a fist fight. There was no need to have a weapon. They testified that they didn't feel like their lives were in danger. They weren't in threat of serious bodily injury. You even heard from two of Misty's friends that were out there. They didn't see a weapon. They didn't know what happened. There's one person that knew what happened, and that one person is Michael Moseley. Michael Moseley knew he had that knife on him the entire time. He knew it when he's inside the bar, when he's approaching Emma Yoder on the dance floor, when he's being aggressive with her, when he's trying to buy her a drink, and she's there with 8 guy friends. Some of them are very tall. He knows he has a knife. He knows when he goes up to her right before they leave at the top of the steps. When Sam Foltz puts his arm around Emma, Michael Moseley knows he is armed with a knife. He has an upper hand. You saw the video from that second floor of the bar. He's talked to Wilson McCullough. He's seen the entire group. He's been able to size them up, and he knows that he is armed with a weapon. When he's walking down those steps, he knows that he's armed with a knife. When he makes that decision outside to punch Sam Foltz in the face repeatedly, when that fight continues, he actually gets punched by Wilson McCullough. That is the one thing that Wilson McCullough did. He punched Michael Moseley after he punched his friend Sam 5 times. And then Wilson McCullough got punched by Michael Moseley and Sergio Alvarado. And Michael Moseley knows that he is armed with a knife when he hops back into that fight after fixing his hair. He knows he has a knife. When he stabs AJ Bethurum in the face, stabbing him in his left eye to where it punctures his eyeball and goes into his skull, he is intentionally trying to take AJ Bethurum's life. He stabs him again and hits his left elbow. That is the moment that Clay Beth came in. And AJ Bethurum has been stabbed in the face and the arm. Michael Moseley got up. He made an intentional decision. He got up, he aimed, and he lunged around JC Harper to stab Clayton Beathard in the chest. He readied himself, he aimed, and he lunged at him. In stabbing, and he did not stop there. That's the involved. After Wilson McCullough has been knocked to the ground, after AJ Bethurum has been stabbed in the face and stabbed in the arm, after his best friend, Clay Beathard, has been stabbed in the chest, that is the moment that Paul Trapeni swings at Mr. Moseley. And you see him swing, and you see Mr. Moseley strike at him. And you see Paul Trapeni, he goes down and pauses. And I submit to you the evidence And the video in this case shows that that is when Paul Trapeni is stabbed in the chest, because his next move is to go in with his left side towards Mr. Moseley to swing at him again. And Paul Trapeni is stabbed in his left back. Michael Moseley knew he had the knife. He knew when he took that knife out, and every single thing that he did from that moment forward, it was intentional, it was purposeful. He almost killed 3 people. I submit to you that the evidence in this case proves the elements of first-degree murder, attempted first-degree murder, and simple assault. All of the evidence that you've heard this week proves that beyond a reasonable doubt. I do want to go through some of that law that we talked about during jury selection, because it is extremely important, and Judge Dalton is about to provide that jury instruction to you. Reasonable doubt is the burden that the state has in this case. And that is the doubt created by an investigation of all of the proof in the case, and an inability after such investigation to let the mind rest easily as to the certainty of guilt. Absolute certainty of guilt is not demanded by the law to convict of any criminal charge, but moral certainty is required, and this certainty is required as to every element of proof necessary to constitute the offense. Again, we discussed this in jury selection, but the jury instruction in the law in Tennessee requires you to first consider the charged offense in the indictment. So for first-degree premeditated murder, you will consider that offense, and unless all 12 of you make a decision that the state has not met our burden and we have not met those elements beyond a reasonable doubt, you will not go on to consider the lesser included offenses. And I submit to you that the proof and evidence and testimony in this case proves first-degree murder beyond a reasonable doubt, and there is no reason for you to consider any of the lesser included offenses. Count, which is an assault that the defendant caused bodily injury to another, and that the defendant acted either intentionally, knowingly, or the assault of Sam, as well as you heard from Sam Folks. He is standing there and he is punched 4 to 5 times in the face. These are out, and I submit that the evidence you've heard this week proves both of those. An attempted first-degree murder. This is the attempted first-degree murder of AJ Bethurum. That the defendant intended to commit a first-degree murder, and that the defendant did some act intending to complete a course of action or cause a result that would constitute first-degree murder under the circumstances, which again, you're gonna get this full instruction. I'm not gonna read the entirety of it to you. He stabbed AJ in the eye. The blade entered his skull. When you stab someone in the face, that is a substantial step towards an attempted first-degree murder, and I submit that you have that evidence before you. The last element is that the victim does have to suffer serious bodily injury. You heard from Mr. Bethurum today, and he described that injury to you. Serious bodily injury is defined under the law, and there are multiple factors that can constitute serious bodily injury. The state only has to prove one of those. However, Mr. Bethurum's testimony today is that he did have a substantial risk of death when Mr. Moseley stabbed him in his left eye. He described the pain that he suffered from that stabbing, but then he also testified that he does not have any vision from his left eye. That is a protracted loss or substantial impairment. And I submit that you have proof of each and every element of that attempted first-degree murder. Counts 1 and 2, the premeditated first-degree murder, the state has to prove that the defendant or someone whom the defendant is criminally responsible unlawfully killed the alleged victim. The second element is that he acted intentionally. A person acts intentionally when it is the person's conscious objective or desire to cause the death of the alleged victim. And the third element is that the killing was premeditated. Count 1 is the murder of Clayton Beathard. Count 2, the same elements, is the murder of Paul Trapeni. The issue for you to determine or not in jury selection from the court. A premeditated act is one that's done after the exercise of reflection and judgment. And that means that the intent to kill must have been instant. There is no time frame. That in this case about direct and circumstantial evidence, that there is, you take from the moment that Clay is stabbed and you go backwards and you see Mr. Moseley on video that entire time. He doesn't leave to go get anything, which means he had that knife on him. He is armed the entire night. You also can go backwards from that moment to see when he took that knife out. That is premeditation. He has the weapon on him, but he arms himself. Now, premeditation, this does not apply to the attempted homicide of AJ Bethurum. And I submit to you that that attempted homicide occurred before Clay Beathard was stabbed. Mr. Moseley has already stabbed twice when he stabs Clay Beathard once. And again, he doesn't stop there. He goes on and stabs Paul Trapeni 2 more times. The definition of premeditation continues, and it says that the mental state of the accused at the time he allegedly decided to kill must be carefully considered in order to determine whether the accused was sufficiently free from excitement and passion to be capable of premeditation. I submit to you that any first-degree murder is going to involve a level of excitement and passion. This is saying it has to make someone incapable of exercising reflection and judgment, incapable of thinking, incapable of making a decision. I submit to you the evidence in this case is not present. Mr. Moseley made decisions. You can see him making decisions in the video. His actions show that he is making a decision after reflecting on it. If the design to kill was formed with premeditation, it is immaterial that the accused may have been in a state of passion or excitement when the design was carried into effect. Premeditation can be found if the decision to kill is first formed during the heat of passion, but the accused commits the act after the passion has subsided. Again, I submit to you, there's not a scenario in which you are committing a first-degree murder in which there isn't going to be some level of passion and excitement. The law is very clear that it would have to make you incapable of making decisions. pocket when he fixes his hair, he goes on to punch Wilson McCullough. There's no stabbing that occurs right in that moment. This moment right here, you do see him with his right hand to that pocket when he's fixing his hair. And this is the exact same frame, the zoomed out version, so you can see the timestamp. That moment, Mr. Moseley makes a decision to go back in to this, what has been described as a tornado. That's the same moment when he fixes his hair. This is the moment when Wilson McCullough is being punched and knocked to the ground, when David Bates goes to his friend. Clay Beathard has swung. AJ Bethurum has just walked up. Mr. Moseley has lunged at him not once but twice. That's when Clay Beathard punches Moseley to the ground. That's when Moseley aims at Clay. He lunges around J.C. Harper. And then he stabs Paul Trapeni twice. Which again, you have that one moment where he fixes his hair, going from punching Sam Folks up by that SUV to the point that he decides to go back and swing and punch more. Thoby Father's knocked over, but Wilson McCullough is punched and knocked to the ground. This is reflection and judgment when Mr. Moseley arms himself. That's the moment he fixes his hair. He's punched Wilson McCullough. I submit to you in this moment right here, that car is blocking Mr. Moseley's right pocket and right hand, but Clay Beathard swings. Now, right here is really important. Mr. Moseley's hand is by that right pocket. He walks behind Sergio Alvarado, and his arm right there in that moment. His right hand is out. AJ Bethurum has approached, putting his arms out. Mr. Moseley gets behind Sergio Alvarado, behind him, and he lunges directly at AJ Bethurum's face. You heard AJ's testimony this morning. AJ Bethurum testified that the moment that he was struck, the very first moment, that is when he is stabbed in the left eye. That moment, his eye goes black, and he knows that something is wrong. But he said that was the stab, that first strike. Clay Beathard punches Mr. Moseley to the ground. J.C. Harper gets in between them. Mr. Moseley has already stabbed AJ Bethurum twice. He is still armed. And he takes this moment. He stops. He crouches down and he lunges at Clay Beathard. Paul Trapeni swings at him. Moseley strikes him here, and then you see Paul go in with his left side towards Mr. Moseley. That is when Moseley is stabbing him again. That's the moment he fixes his hair. Mr. Moseley makes that decision to arm himself when nothing is happening. Nothing is happening. Clay has swung at him, but he's standing there. He's with Sergio Alvarado and J.C. Harper. His friend Daniel's walking towards him. And AJ Bethurum. Clay Beathard isn't doing anything to Mr. Moseley right now. AJ Bethurum walks up with his arms out. He has already armed himself, and he gets behind Sergio Alvarado just like he gets behind JC Harper when he stabs Clay in the chest, and he lunges forward directly at AJ Bethurum's face, not with a punch, with a knife to stab him in the eye. You see him again right here. He lunges in again. AJ's left arm. Mr. Moseley has just stabbed someone twice. Clay Beathard is trying to defend his friend, and he punches him and knocks him to the ground. Mr. Moseley decides to get up, still with his knife, because he's already armed himself. Before he ever stabs Clay Beathard, he's armed himself and stabbed AJ Bethurum twice. That is reflection and judgment. But this right here, where he crouches down and takes aim and lunges around JC Harper, that in and of itself is reflection and judgment. And then he stabs Paul Trapeni directly in the chest, and he doesn't stop there. He stabs him again in his side and his back. This is a still image of that moment. That moment when Mr. Moseley has to have armed himself based on the evidence in this case. His right hand is out, and he is behind Sergio Alvarado. Mr. Bethurum testified today that he went to swing at someone, and he knew it was not Mr. Moseley. Mr. Moseley gets behind Sergio Alvarado. He gets behind him. And AJ Bethurum said he knew it came from the left, but that he was confronting someone that was not Mr. Moseley. And he gets stabbed. Which again, Mr. Moseley walks calmly away. I submit to you that the testimony and proof that you've heard all week is that Mr. Moseley intentionally stabbed AJ Bethurum. He did that in an attempt to kill him when he stabbed him in the face. He purposely tried to take AJ Bethurum's life. He wanted to take him where his family and friends would not have him here with them anymore. The evidence that you have is that is his intention when he stabs him in the face and keeps stabbing him. You see injuries that he stabbed him directly in the eye. And again, he didn't stop with one stab. He keeps stabbing him again in his left arm. The testimony and evidence that you've heard in this case is that after he has stabbed AJ, after, he's already had time to reflect he's already made multiple decisions. Number one, he armed himself in a fist fight that he started. He started the fist fight and then he pulled out a knife and he attacked a man that was standing like this with his arms out. He attacked him, stabbed him in the face, stabbed him in the elbow. All of that has occurred before he ever stabs Clay. Reflection and judgment, it is premeditation. It was Mr. Moseley's desire to take Clay Beathard's life, and he did. He took him from his friends and family who will always be without him. That joy and kindness that you heard so many people talk about, he took that. Paul Trapeni, he's already armed himself in a fist fight that he started. He's already knocked Wilson McCullough to the ground. He's already stabbed AJ Bethurum twice. And he knows he stabbed Clay in the chest. He took that lunge. And Paul Trapeni, he intended to take his life. He stabbed him directly in the center of his chest. He decided to do that. Mr. Moseley intended to take Paul Trapeni from his friends and family. He intended to end his life. All of the happy, joking, gone forever. That was his intention, and that's the evidence in this case. Mr. Moseley committed a first-degree premeditated murder when he killed Clay Beathard and Paul Trapeni. He intended to kill AJ Bethurum, but he did fail at that. But I submit to you that there is proof beyond a reasonable doubt that Mr. Moseley is guilty of all 4 counts of the indictment. And I ask that you return that verdict.
Okay, Mr. Quill, you ready to present your closing argument?
Yes, Your Honor. I'm going to make a few remarks, and then I'm going to play a very short video, which includes some of the pictures and videos you've seen before. Several points. No one saw a weapon, and there was no blood on the knife recovered from the vehicle. No knife on the video. No blood. Well, there's blood on the street, but the blood doesn't start till everybody's on that far sidewalk. Officer Terry testified about a Faro scan, and the geography of that location is important, I think, because from the Dogwood Bar, you've got 2 lanes, a sidewalk that's about 8 feet deep, and then a little sidewalk leading up to a masonry porch. It's about 25 feet high with a little iron railing around it, and it's all between 2 hedges. So once you're back there, you're sort of locked in. You're very limited in your movement.
Now, I gave Patrick Wells kind of a hard time, but the point of that was, here's a college defensive back who was intoxicated to the point of stumbling a little bit, but had no problem remembering everything. In contrast to Wilson McCullough, who was either untruthful or blackout drunk. Now, the wild cards, the two folks that run into Mr. Bethurum's back still don't know why or really who they were. It may be they saw Mr. Bethurum push J.C. Harper, just don't know. And when Mr. Bethurum starts his beeline across the street and ends up, whether or not he pointed or whatever he did, they start to veer off. They are chasing Michael Moseley and Sergio. Sergio and Michael, their cars are back that way and they're heading in that direction. But Mr. Trapeni and Mr. Beathard and Mr. Bethurum, they just keep going. Now let's play this video that starts out with a picture of this. Start back again, please. Beginning. Picture of it. Right, you got it at the beginning?
Great.
So, okay, no. And I actually didn't, when we first talked to Detective Chandler on this, we talked to him in the hospital. I went in, he's like, well, did you see an altercation in the bar? And I was like, no. He's like, are you sure? And I was like, yeah. So I went out in CDR and I was like, something. Like, I did not know of anything, to my knowledge of what I saw or heard, and it was my best friend. She did not mention it to me when we were in the bar.
Between the person that was arrested for this and anyone in your group or anyone in his group.
Yeah, you want me to just tell you what I remember? It's really, from talking to everyone else, I think mine might honestly be the least helpful, but.
Well, that's fine. This,
Yeah. So I just found out, all I remember, I didn't see anything happen inside the bar. I didn't see anyone get approached.
All right, Mr. Moseley in a chokehold, Wilson McCullough winding up to throw the punch. Right punch. Then on the left, 248-39, Mr. Moseley's in a headlock. 248-43, Mr. Beathard on the left, and Mr. Bethurum on the right, both pointing. From another camera angle, same time, 248-43, Mr. Beathard pointing. And here, this shows the disparity. Mr. Bethurum looks like a giraffe compared to Michael Moseley, Sergio Alvarado, and Ms. Harper. He towers over them. And Mr. Bethurum shoves J.C. Harper. You see, now he goes in for this punch. He clearly has not been stabbed at that point. Now, you see Michael Moseley in the low, upper right corner there on the grass. He falls on the grass to the east of the live music sign. Then we'll see it from the other angle, and the time frame overlaps a little bit. Now watch, Mr. Beathard winds up, Moseley looking to his left, hands at sides, down the grass. Ms. Harper tries to push away Mr. Beathard. Again, and it's apparent that Mr. Beathard was putting everything he had into it. And Mr. Trapeni starts in. Okay, the wild cards.
a mystery. But Mr. Bethurum's clearly on the sidewalk when they hit him. Mr. Trapeni goes in. They're back on the grass there, the far side of the far sidewalk. Now, moving on to the jury instructions, which you'll be given soon. I would note that the fighting stops when Mr. Beathard and Mr. Trapeni were on the next side of the street beyond the sidewalk. Mr. Beathard jogs away and Mr. Trapeni walks. And at that time, almost seconds or two later, 2:49:10, you see Mr. Moseley, Ms. Harper, Daniel Sevilla, and Sergio Alvarado. They walk to their cars over there. They don't run, but they just go naturally. And they testify that they don't, or at least some testified that they didn't know anything really serious had happened until the next day, till the media reports. Now, I asked Mr. Folks if he shoved Mr. Moseley before Mr. Moseley hit him. He said no. But if you look at the staircase video at the end, you'll clearly see Mr. Folks shove Mr. Beathard out the door. Have Mr. Folks sort of drunkenly getting into, maybe it's a friendly shoving match, but he's shoving somebody. And then later on, he goes up to Wilson McCall. Starts his way of handling. Now, the suggestion that Mr. Moseley was in a process of flight, contrast on the call from Attorney Johnson and the phone call the next day. The detective has a busy schedule, I'm sure, but some of the other difficulties in apprehending Mr. Moseley could have avoided if he could have just have been surrendered, which attorneys do. Now, Mr. Moseley had a right to be on that public street. And I want you to consider the self-defense instruction that the judge will give you. And one of the things to consider are previous threats. And I would suggest that when a man angrily walks towards you and points at you, that is a threat. And if a man is shaking his finger at you, that is a threat. If a man has held you in a headlock, that is a threat. Another thing to consider is the relative strengths and sizes. Of course, we showed you that one storm over everybody. And I don't really know how tall Mr. Beathard was. The low estimate was 5'10". From the medical examiner, you would think that would be accurate. And then Mr. Wells said 6 feet, which seems to comport with what Mr. Bethurum said. But either way, he weighed 194 pounds. He was very strong and at 70 pounds, whatever. Mr. Moseley, I don't. Seen variously reported as he's a smaller man, I'll say that. Now, when you've seen the video and you either agree with me or not, Mr. Moseley's standing there at the edge
of the far sidewalk, kind of looking this way, hands at his right side. Mr. Beathard starts to come up. J.C. Harper sees what's happening and starts to come this way. And maybe at the last minute, Mr. Moseley looks towards his right, but it's not in time. And the punch comes across here. Mr. Moseley does crumple on the grass. You can see it from that picture where Mr. Bethurum throws the punch. I believe that's in evidence, and you can take your time and look at it. So it's visible from that camera and also the winners and losers / camera from down the street. Now, if somebody hits you when you're not looking, that would involve, I think, a substantial risk of protracted unconsciousness. Mr. Moseley was not knocked unconscious, but that was not because Mr. Beathard held back on that punch. You can see that he put what he had into it. The burden of proof, you'll find that it is on the state to prove beyond a reasonable doubt that Mr. Moseley did not act in self-defense. And I'll ask you to hold him to that burden. I think that's close to what I have for you. If you'll be patient with me for just a moment. It's time to address you. There's also an instruction about voluntary manslaughter, I think, and it talks about passion and what would arouse such a passion that would make someone violent, more or less. But I would suggest if someone hits you while you're not looking, that would arouse a great deal of passion. I thank you for your time and patience, and very attentive jury. Appreciate it.
Does the state wish to make a final close?
Yes, Your Honor. And Your Honor, may I use the computer screen?
Yes.
Members of the jury, today, AJ Bethurum came into this courtroom and he echoed all of his friends who testified before him in telling you about the character and the integrity of his friends who died at the hands of Michael Moseley. He told you about Clay Beathard, had it all. He was godly. He said that Paul Trapeni was the funniest person he said she's honest. And then I started thinking back about fun and enjoying each other. Michael Moseley not only robbed Paul Trapeni and Clay Beathard's friends and family, robbed all of us. Those men were going places. Those men were going to be incredible. And this defendant robbed all of us. And he robbed them. And he robbed them. And he must be held accountable. The defense in this case wants you to consider self-defense. The defense wants you to find Michael Moseley not guilty acted in self. It was interesting to me because there is a lot of law that you're about to be read by the bring up to this case. It 100% does not apply to Michael Moseley. It just doesn't. So I want to take a minute and go over the law of self-defense with you. There are many reasons in the law that self-defense doesn't apply to this case. Self-defense is only available when and to the degree the defendant reasonably believed the force was immediately necessary to protect against the alleged victim's use of unlawful force. So if you take this and you look at all of the things that the defendant did and when he did it and why he did it, you will see that he is completely knocked out of even having self-defense apply to him and his actions in this case. If you start with Sam Folks, Sam Folks didn't do anything. Even by the testimony of the defendant's own friends who were there, the only thing that Sam Folks did was maybe hurt the defendant's pride when he put his arm around Emma and said, "Stop talking to her. She has a boyfriend. I'm her boyfriend. Stop talking to her." That's it. And the next interaction the defendant has with Sam Folks is to completely unprovoked hit him the way that you saw him hit him, punch him 4 times, not softly. There was nothing, and punch and punch. Nothing was immediately necessary for him to do at that time. You know, I think back to something my mom told me when I was growing up. Sticks and stones may break my bones, but words will never hurt. Only been done about when he stabbed AJ Bethurum. AJ Bethurum, when the defendant decided to try to kill him. It was not immediately necessary for him to do anything. The defense would have you to believe he was backed into a corner and had no way to go. But you know better than that because you have the video and you can see it. The defendant could have walked away. But instead, after he hit Sam Folks, after he hit Wilson McCullough, that's when he goes in. And when AJ has the gall to walk up and try to stop the situation and go like this, that's when he stabs AJ Bethurum. It wasn't immediately necessary for him to do anything at that moment. And then after that happens, that's when he decides to fight Clay. Nothing was immediately necessary for anything from happening. Nothing had to happen. The defendant made the choice to go around J.C. Harper and stab and kill Clay Beathard. It wasn't immediately necessary at that time. None of it was. And then after that, he chooses to go not immediately necessary. He decides to murder him at that time. Self-defense does not apply. But the law of self-defense goes on. And if you continue reading the law, you can see how it still doesn't apply. If the defendant was in a place where he had a right to be, and I want to pause right there because the judge is going to tell you that you are the judges of the law and you are the judges of the facts in this case. Do you think he had a right to be there? That's a decision for you to make. We know that the whole reason he went there that night is because he was with Sergio Alvarado, and Sergio Alvarado had drugs that he wanted to sell. And it was very clear that Michael Moseley was there that night so that he could help him sell drugs. J.C. Harper said that's the whole reason they went. So you decide whether or not he was in a place he had a right to be. And then it goes on to say he would have the right to use force intended or likely to cause death or serious bodily injury if the defendant had a reasonable belief that there was an imminent danger of death or serious bodily was real or believed to be real at the time, and the belief of danger was founded upon reasonable grounds. Again, the defendant began this fight. He chose everything about it. There was nothing to go through all of the list again, but there's no way that any person, no matter how tall or short you are, would have any reasonable belief that this group of people was out to get him. You saw the picture they took at the beginning of the night. You saw them when they were walking down the stairs, laughing, joking with the staff at the bar, laughing, joking with each other, just walking out there trying to get their Ubers. Nobody could reasonably believe that they had to defend themselves against this group of people. There are things reasonable. Number one, the force itself. In this situation, the force itself was not reasonable. The defendant killed 2 people. And number 3, the previous threats the victim has made to the defendant. Nobody heard anybody make a threat towards the defendant. Number 4, the character of the victim for violence. You heard person after person after person come in here. All of the witnesses had a character for violence. They weren't people who picked fights. They weren't people who egged on fights. They weren't people who carried weapons. Number 5, the animosity revealed to the defendant words of the only thing that could even come close to this would be Sam Folks saying, stop talking, and that anything. And the manner in which the law of self-defense goes on, and it says, and you will be instructed this by the judge, the use of force against the victim is not justified if the defendant provoked the victim's use of unlawful force, unless the defendant abandoned the encounter or clearly communicated to the victim the intent to do so, and the victim nevertheless continued to use unlawful force against the defendant. Okay, so it's not justified if the defendant provoked the victim's use of unlawful force. First of all, the state is not saying that any of the victims in this case used unlawful force. That is not what we're saying. But even if they had, self-defense would not apply here. The defendant provoked it. We asked every single person during voir dire, do you think a person should be able to claim self-defense if they're the person who started the event? Every single person agreed that you can't. That's what the law of self-defense is. The judge is also going to instruct you on the law of defense of third person. And I would submit to you that the defense of a third person does not apply to the defendant, but it does apply to Clay Beathard, Paul Trapeni, and AJ Bethurum. And that law says that a person is justified in threatening or using force against another to protect a third person if, under the circumstances as the person reasonably perceives them to be, the person would be justified under the principles which apply to self-defense in threatening or using force to protect against the use or attempted use of unlawful force reasonably believed to be threatening to the third person sought to be protected. The reason I bring this up is because you will see that under the law of defense of third persons, that Clay Beathard had every reason to punch the defendant. Wilson McCullough had every reason to hit the defendant. Paul Trapeni had every reason to be there trying to keep the defendant from hurting anybody else. He had just seen one of his best friends stabbed. AJ Bethurum had every reason to walk across that street and stand there like this and demand answers for what he saw the defendant doing to his friends. The defense wants you to consider voluntary manslaughter, and the state would ask you not to. And here's why. It doesn't apply to this situation. It's not appropriate. First, General Norman talked to you about how you have to, when you go back to deliberate first on premeditated first-degree murder. The state is confident that that's where you'll stop because we proved first-degree premeditated murder. If you find the defendant guilty of that, you don't go to any lesser included offense. Even if you did go to a lesser included offense, the next one in between first-degree murder and voluntary manslaughter is second degree. The only thing that second-degree murder requires is a knowing killing. I know that if I stab you as hard as I possibly can in your heart, you could die. I know that if I stab you as hard as I possibly can anywhere in your torso, you could die. I know that if I stab you as hard as I can and it reaches your skull, it could kill you. That's a knowing murder. We don't think that you're even going to get there, but you would have to bypass both of those before you even got to voluntary manslaughter. And then voluntary manslaughter is not appropriate. Your patience. Stones may break my knee. The only thing that was ever said to him to start this entire thing were words. Stay away from this girl. The adequate provocation also must lead a reasonable person to act in an irrational manner. The defendant was not being reasonable that night. He went to a place to sell drugs. He got his pride hurt a little when he couldn't buy a drink for Emma Yoder, and that was it. And then that led to everything that you saw outside. Self-defense would, however, have been appropriate in this situation if either Paul Trapeni, AJ Bethurum, or Clay Beathard had seen the defendant with a knife. The law of self-defense says they could have gotten out a gun and shot him. That's how self-defense would have applied in this case, but none of them had a weapon. The state would ask you all to consider not only the eyewitness accounts of the friend group that went out that night with all of the victims in this case, but also the testimony of Miriam Mendoza, Clarabelle Bernal, Jorge Gardia, Mario Rodriguez. These are all people who just went out to a bar that night. They were all in the middle of it. They were all very close to everything that happened that night. And every single one of them said that they did not think a weapon was necessary to protect themselves. That goes back to, was the defendant acting reasonably? Was it immediately necessary for him to do what he did? None of them thought that it was. Even the testimony of Daniel Sabia and J.C. Harper. The only thing that Daniel heard was bickering. And the only thing that J.C. Harper said was that they were not being respectful. Also, the state would ask you to consider the testimony of J.C. Harper. She clearly didn't want to be here. She knew that the whole reason that they were there was to sell drugs. She testified that she even watched from that second-story balcony to make sure with Daniel that the defendant was okay as he went to go make this drug transaction or walk to the ATM. But consider what she said. JC Harper said that she heard something happening and she ran up the steps so that she could get in the middle of it and diffuse a situation. She physically, you can see in the video, grabs onto Michael Moseley and pulls him aside. And you can see her gesturing to everyone else. Go on, go on. She's holding him back, telling the rest to go. And then she testified that after that, because she knows Michael Moseley, she's watching him. She's keeping an eye on him. Once they get down to the bottom of the stairs, she hears him say, "We're gonna fight him." And that goes back to reflection and judgment. Reflection and judgment. Did the defendant act with premeditation? Yes, we're gonna fight him. He knew what he was gonna do. He knew he had a weapon. And then consider what continued to happen after she picked up her items that she the street and continues to get in between herself and Clay. I submit to you because she knows what the defendant is capable of. She knew that. So we would ask you to consider that. I also want to talk a little bit about page 28 of your jury instructions. There's an instruction called the flight instruction, which says that you may infer that a defendant is guilty if they leave the situation and hide out in the community. In this case, we have the defendant who, as soon as he got done murdering 2 people and doing his best to murder a third, he walked away from the incident. We don't have any proof that he called anybody. That he tried to get them and he walked away. He chose, first he got into a car with Daniel Sevilla and Jason. But then he chose to get out of the state, hidden out in the community. Try to keep it from guilty. Defense brought up during this case as well. Just that Wilson McCullough is somehow responsible for all of this happening is not only offensive, but it's ridiculous and unconscionable. He had nothing to do with any. Try to make it look or seem as if it had anything to do with him or with Emma Yoder is just flat out wrong, and it's cruel to do to these people. The defense would have you believe that the defendant was being ganged up on by a group of super tall athletes, when in reality, the defendant wasn't being ganged up on by anybody. The defendant started a fight along with other people that he was with. He was with a person who was on federal probation at the time and who was there selling drugs. And he chose to be with him. They made a plan together. We're going to go fight these people. And then he goes and he does it. So he's assisted not only by Sergio Alvarado, but also Daniel Sevilla was there and JC Harper was there, engaged in trying to push people away. I would submit to you that the defendant acted extremely cowardly that night, because when JC Harper came and was first of all, he hid behind Sergio Alvarado at one point. JC Harper gets in between the defendant and Clay, and he is kind of behind JC and then goes back behind JC after he stabs Clay Beathard. And then the defendant cowardly walks away from the situation. I also want to address the defense trying to bring down Patrick Wells as though somehow he is involved in this or had anything to do with any of this. And also Sam Folks, that he had anything to do with this because he was horsing around in a physical way with friends of his that he hasn't seen in a really long time. Both of them were cross-examined extensively about it, And once again, it's unconscionable to try to blame what this defendant, this murderous defendant, did on these two men, or try to make it look like they had anything to do with it. The fact is that the defendant made all the choices that night. He chose to go to Dogwood. He chose the company that he was going to go with. He chose a drug dealer who was on probation. He chose his victims. You know, a lot has been said about who's tall and who's not tall, and who's a little bit taller and who's a little bit shorter and everything like that. Just as General Norman said, when he was up there, he was sizing everybody up. And when he went out to the sidewalk out there and he chose to punch and assault Sam Folks, he was getting somebody who was a little bit more of his size. And he did the same thing when he then moved on to Wilson McCullough. But when people started coming to their aid, the taller and bigger people, that is when he cowardly chose to pull out his knife and use it. He chose who he was going to hit, and he chose who he was going to stab. And he chose to walk away, and he chose to leave with Sergio Alvarado, and there's no evidence that he tried to help anybody. We talked about premeditation, and General Norman spoke a lot about it. I want to just say this one other thing. We talked about how premeditation doesn't require any particular amount of time. We talked about how you could be driving through a yellow light and making a decision, and it happens just like that. I'm either going to slow down and stop, or I'm going to go on through it. That's all it takes, reflection and judgment. The defendant used reflection and judgment. As General Norman said, he knew he had a knife in his pocket. He knew he did, okay? So at some point when he's out there, he has to make the choice. I am moving now from beating people up with my hands, and now I'm going to decide to go ahead and use my knife. So I'm going to have to get my knife out. I'm going to have to open that knife up, and I'm going to have to crouch down in in the way that he did, and that's when he decided to go out and use it. The defendant made choices. He used reflection and judgment. He chose his victims. He chose who he was going to stab. He chose to take it out of his pocket. He chose to open it up, and he chose to use it. That is premeditation all day long. But even if you don't think that was enough to be premeditation, it started back on the sidewalk when he was in communication with Sergio Alvarado, and he said, "We're gonna fight him." I also would ask for you all to consider the evidence that we heard in the autopsy from the medical examiner when she spoke about the autopsy. Remember that there were no injuries to Clay's hands, to Clay Beathard's hands, and there were some injuries to Paul Trapeni's hands, but those were explained by his father who testified. And then compare that to the photographs that were taken of the defendant. The defendant had no injuries on him. The only injury that he had was on his right hand, where one would expect, if you're stabbing somebody, the hilt of that knife, if you're stabbing somebody so hard that it's going to go all the way through their chest and into their heart and into their lung, that knife is going to cause that injury that he had to his hand. So the state would ask you to consider that. The only evidence that you can consider in this case when you're determining whether or not the defendant is guilty of all of these crimes is the evidence that was presented to you. The judge is going to read you an instruction on witness credibility. And in that instruction, it's going to say that the law presumes that all witnesses are testifying truthfully. You can't invent some type of reasonable doubt because you think that if so-and-so had testified, then this is what the evidence may have been. You're constrained by the evidence that has been presented to you. That's why the judge has been so careful to tell you not to look at any other thing. And the reason I bring that up is because every single witness that you heard from, and there were a lot of them, every single one of them support a finding of guilty in this case. The only evidence that you have heard is that the defendant is guilty. Even the defendant is guilty. Even the defendant's own friends support a finding of guilt. All of them said they basically testified to you, whether they knew it or not, that self-defense was not immediately necessary, that self-defense was not reasonable. It's not a defense that you can even consider, because none of them saw a weapon. And we talked in voir dire about you can only, it's self-defense is only available when and to the degree is immediately necessary. So we talked about in voir dire, if I threw my pen at Miss Norman and she couldn't then pick up a gun and shoot me. Well, the same thing applies here. The defendant used a knife, and that was inappropriate. I want to mention too, the defense made a big deal about Thoby Favre, and that when she initially spoke with detectives, that she did not say some of the things that she testified here about this week in this trial. I think Ms. Favre explained herself very well, that she misunderstood the detective's question. He said, "Did you see him hitting on her?" And she immediately said, "No, I didn't see an altercation in the bar. I didn't see an altercation when I was in there." And so she was answering a different question than the detective asked her. And for the defense to try to say that she was anything but truthful because of that slip up when she just witnessed her friends being killed and was in the process of going to their funerals is inappropriate. The defense said in his closing argument that the fighting stops when Paul and Clay leave the situation. The fighting stopped when the defendant decided to put his knife down and walk away. The fighting that was happening out there had nothing to do with Paul Trapeni or Clay Beathard. It absolutely did not. The only reason he brings that up is because they were completely immobilized at that point. They only had enough strength to walk across the street where they laid down and eventually had to be helped by paramedics and taken to the hospital, where they eventually passed away. I've done my best to let you know about the law of self-defense and to respond to some of the things that the defense has said in their closing argument and during this trial. And now it's time for you to apply the facts that you heard in this case and apply it to the law. The state would submit to you that there is nothing that you all can do to make AJ Bethurum's life any easier. There's nothing that you can do to bring back Clay Beathard. There's nothing that you can do to bring back Paul Trapeni, but we can ask you to get justice. We can ask you to hold the defendant accountable for what he did. And that's what we're doing. Thank you.
Your Honor, may we approach?
Hey guys, I'm back for right now. Thanks for everything you guys are mentioning about hoping I feel better. Um, yeah, I'm surprised he didn't testify. I mean, you kind of have to, man. I mean, given what they're alleging and all that, it's like, jeez. I mean, he's probably toast at this point. I mean, I don't know why you don't. Um, but yeah, so we'll have Thursday night tonight, guys. I'm kind of like, oh, we'll make it happen one way or another. Um, so we'll have Thursday night tonight, guys. I'm sick today, so wasn't feeling good. I was gonna try to do like Punished Sean or like Punished Snake, but I'm not sure everybody would get the Metal Gear Solid references. So, um, yeah, right now it. So yeah, they're done, and Dr. Husel's done. Surprisingly, I'll just recap Dr. Husel. We talked about last week with that Dr. Zivit that was going to be excluded. He testified yesterday and today, and they're done. Yeah, I think they are pretty confident in their case, and I don't blame them at this point. Dr. Zivit, I'll try to cut up some of his testimony. I know somebody I know who watched it. It's pretty interesting. He was very good at what he did. Oh, ow, that's loud.
We're about to read the jury charge. It will probably, if I look at the number of pages, or you page by that, this will probably take me about 30 minutes, give or take. If anyone in the audience, you're welcome to stay during the jury instruction. It's just me reading something. You're welcome to stay if you'd like. If you want to be excused now, what's the time? But you're welcome to stay. I'm not putting anybody out, but if you just want to be, it's not the most exciting,
God, I hate this part.
part of the trial, I can tell you that. Ladies and gentlemen, as they're leaving, as I mentioned at the beginning of the trial, I will read to you the jury instruction. I'm required to read this. It'll take me about 30 minutes, give or take. You will get
God, I hate jury instructions.
Back with you to the jury room, but you still have to be attentive as I read it to you. Okay, we'll let everybody get settled. Okay. In the criminal court for Davidson County, Tennessee, Division 2, State of Tennessee versus Michael David Moseley, case number 2020B 978, first-degree murder, attempted first-degree murder, assault. Charge. Members of the jury, counts 1 and 2 of the indictment in this case charge the defendant, Michael David Moseley, with the offense of first-degree murder upon the alleged victim, Clayton Beathard, as to count 1, and upon the alleged victim, Paul Douglas Trapeni, as to count 2. This offense embraces the lesser included offenses of facilitation of first-degree murder, second-degree murder, facilitation of second-degree murder, voluntary manslaughter, facilitation of voluntary manslaughter, reckless homicide, facilitation of reckless homicide, criminally negligent homicide, and facilitation of criminally negligent homicide. Count 3 of the indictment in this case charges the defendant, Michael David Moseley, with the offense of attempted first-degree murder upon the alleged victim, Alva J. Bethurum. This offense embraces the lesser included offenses of facilitation of attempted first-degree murder, attempted second-degree murder, facilitation of attempted second-degree murder, attempted aggravated assault, facilitation of attempted aggravated assault, attempted voluntary manslaughter, facilitation of attempted voluntary manslaughter, attempted reckless endangerment, and facilitation of attempted reckless endangerment. Count 4 of the indictment in this case charges the defendant, Michael David Moseley, with the offense of assault upon the alleged victim, Samuel Folks. This offense embraces the lesser included offense of attempted assault. The indictment in this case is the formal written accusation charging the defendant with these crimes. It is not evidence against the defendant and does not create an inference of guilt. To this indictment and each count thereof, the defendant has entered a plea of not guilty. During this trial, you heard evidence of alleged drug activity. Evidence of drug activity is only to be considered by you for the context of why Mr. Moseley and his companions went to the Dogwood Bar and not as to the guilt or innocence of the charges in this indictment. The evidence in this case has been completed, and it is now my duty to instruct you as to the law. The law applicable to this case is stated in these instructions, and it is your duty to carefully consider all of them. The order in which these instructions are given is no indication of their relative importance. You should not single out any one or more of them to the exclusion of another or others, but should consider each one in light of and in harmony with the others. At times during the trial, I have ruled upon the admissibility of evidence. You must not concern yourself with these rulings. Neither by such rulings, these instructions I have made, do I mean to indicate any opinion as to the facts. Statements, arguments, and remarks of counsel are intended to help you in understanding the evidence and applying the law, but they are not evidence. If any statements were made that you believe are not supported by the evidence, you should disregard them. You are the exclusive judges of the facts in this case. Also, you are the exclusive judges of the law under the direction of this court. You should apply the law to the facts in deciding this case. You should consider all of the evidence in the light of your own observations and experience in life. The law presumes that the defendant is innocent of the charges against him. This presumption remains with the defendant throughout every stage of the trial and is not overcome unless, from all the evidence in the case, you are convinced beyond a reasonable doubt that the defendant is guilty. A defendant is criminally responsible as a party to the offenses charged or any of the lesser included offenses if the offenses were committed by the defendant's own conduct, by the conduct of another for which the defendant is criminally responsible, or by both. Each party to the offense may be charged with the commission of the offense. A defendant is criminally responsible for an offense committed by the conduct of another if, acting with the intent to promote or assist the commission of the offense or to benefit in the proceeds or results of the offense, a defendant solicits, directs, aids, or attempts to aid another person to commit the offense. Before you find the defendant guilty of being criminally responsible for said offenses committed by the conduct of another, you must find that all the essential elements of said offenses have been proven by the state beyond a reasonable doubt. Further, you are instructed that the defendant may be guilty of facilitation of a felony if, knowing that another intends to commit a specific offense, but without the intent required for criminal responsibility as set forth above, the person knowingly furnishes substantial assistance in the commission of the offense. I shall now proceed to explain to you what in law it takes to constitute the offenses as charged in the indictment in this case, as well as the lesser included offenses. Counts 1 and 2, first-degree murder, premeditated killing. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant or one for whom the defendant is criminally responsible unlawfully killed the alleged victim, and 2, that the defendant acted intentionally. A person acts intentionally when it is the person's conscious objective or desire to cause the death of the alleged victim, and 3, that the killing was premeditated. A premeditated act is one done after the exercise of reflection and judgment. Premeditation means that the intent to kill must have been formed prior to the act itself. It is not necessary that the purpose to kill pre-exist in the mind of the accused for any definite period of time. The mental state of the accused at the time he allegedly decided to kill must be carefully considered in order to determine whether the accused was sufficiently free from excitement and passion as to be capable of premeditation. If the design to kill was formed without premeditation, it is immaterial that the accused may have been in a state of passion or excitement when the design was carried into effect. Furthermore, premeditation can be found if the decision to kill is first formed during the heat of passion, but the accused commits the act after the passion has subsided. Before the defendant can be convicted of any degree of homicide, the state must have proven beyond a reasonable doubt that the death of the that the death of the deceased was proximately caused by the criminal conduct of the defendant, by the conduct of another for whom the defendant is criminally responsible, or both. The proximate cause of a death is that cause which, in natural and natural and continuous sequence, unbroken by any independent intervening cause, produces the death, and without which the death would not have occurred. If you find from the proof beyond a reasonable doubt that the defendant is guilty of first-degree murder as charged in the indictment by the defendant's own conduct or by the theory of criminal responsibility as explained on page 4, you will so report by use of the verdict form that will be provided for you. If you find the defendant is not guilty of first-degree murder, or if you have a reasonable doubt as to his guilt of this offense, then and in that event, you must acquit him of this offense and next consider the defendant's guilt or innocence of facilitation of first-degree murder, which is a lesser included offense. Lesser included offenses as to counts 1 and 2. Facilitation of a felony. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant knew that another person intended to commit the specific offense but did not have the intent to promote or assist the commission of the offense or to benefit in the proceeds or results of the offense, and 2, that the defendant furnished substantial assistance to that person in the commission of the offense, and 3, that the defendant furnished such assistance knowingly. Facilitation to commit a felony as to counts 1 and 2 of this instruction applies to the offenses of first-degree murder, second-degree murder, voluntary manslaughter, reckless homicide, and criminally negligent homicide. What in law it takes to constitute each of these offenses and the definitions related thereto are explained to you in these instructions. Knowingly means that a person acts knowingly with respect to the conduct or the circumstances surrounding the conduct when the person is aware of the nature of the conduct or that the circumstances exist. A person acts knowingly with respect to a result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intent means that a person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. Second-degree murder, knowing killing of another. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant or one for whom the defendant is criminally responsible unlawfully killed the alleged victim, and 2, that the defendant acted knowingly. Knowingly means that a person acts with an awareness that his conduct is reasonably certain to cause the death of the alleged victim. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intentionally means that a person acts intentionally when it is the person's conscious objective or desire to cause the death of the alleged victim. Voluntary manslaughter. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant or one for whom the defendant is criminally responsible unlawfully killed the alleged victim, and 2, that the defendant acted intentionally and knowingly, and 3, that the killing resulted from a state of passion produced by adequate provocation from the alleged victim sufficient to lead a reasonable person to act in an irrational manner. The distinction between voluntary manslaughter and second-degree murder is that voluntary manslaughter requires that the killing result from a state of passion produced by adequate provocation sufficient to lead a reasonable person to act in an irrational manner. The definitions of knowingly and intentionally as applied to this instruction have been previously explained to you. Reckless homicide. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant or one for whom the defendant is criminally responsible killed the alleged victim, and 2, that the defendant acted recklessly. Recklessly means that a person acts recklessly when the person is aware of but consciously disregards a substantial and unjustifiable risk that the alleged victim will be killed. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all circumstances as viewed from the accused person's standpoint. The requirement of recklessly is also established if it is shown that the defendant acted intentionally or knowingly. The definitions of intentionally and knowingly as applied to this instruction have been previously explained to you. Criminally negligent homicide. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant's conduct or one for whom the defendant is criminally responsible resulted in the death or of the alleged victim, and 2, that the defendant acted with criminal negligence. Criminal negligence means that a person acts with criminal negligence when the person ought to be aware of a substantial and unjustifiable risk that the alleged victim will be killed. The risk must be of such a nature and degree that the failure to perceive it constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the accused person's standpoint. The requirement of criminal negligence is also established if it is shown that the defendant acted intentionally, knowingly, or recklessly. The definitions of intentionally, knowingly, and recklessly as applied to this instruction have been previously explained to you. Count 3, criminal attempt to commit first-degree murder. For you to find a person guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant intended to commit first-degree murder, and 2, that the defendant did some act intending to complete a course of action or cause a result that would constitute first-degree murder under the circumstances as the defendant believed them to be at the time, and his actions constituted a substantial step towards the commission of first-degree murder. The defendant's actions do not constitute a substantial step unless the defendant's entire course of action clearly shows his intent to commit first-degree murder, and 3, that the victim suffered serious bodily injury. Intending means that a person acts intentionally when it is the person's conscious objective or desire to cause the death of the alleged victim. The essential elements necessary to constitute the underlying offense of first-degree murder are that the defendant unlawfully killed the alleged victim, that the defendant act intentionally. A person acts intentionally when it is the person's conscious objective or desire to cause the death of the alleged victim, that the killing be premeditated. A premeditated act is one done after the exercise of reflection and judgment. Premeditation means that the intent to kill must have been formed prior to the act itself. It is not necessary that the purpose to kill pre-exists in the mind of the accused for any definite period of time. The mental state of the accused at the time he allegedly decided to kill must be carefully considered in order to determine whether the accused was sufficiently free from excitement and passion as to be capable of premeditation. If the design to kill was formed with premeditation, it is immaterial that the accused may have been in a state of passion or excitement when the design was carried into effect. Furthermore, premeditation can be found if the decision to kill is first formed during the heat of passion, but the accused commits the act after the passion has subsided. Serious bodily injury means injury that involves a substantial risk of death, protracted unconsciousness, extreme physical pain, protracted or obvious disfigurement, or protracted loss or substantial impairment of a function of a bodily member, organ, or mental faculty. If you find from the proof beyond a reasonable doubt that the defendant is guilty of attempted first-degree murder as charged in count 3 of the indictment by the defendant's own conduct or by the theory of criminal responsibility as explained on page 4, you will so report by use of the verdict form that will be provided for you. The court will thereafter set the punishment after a separate sentencing hearing. If you find the defendant not guilty of attempted first-degree murder, or if you have a reasonable doubt as to his guilt of this offense, then in that event, you must acquit him of this offense and next consider the defendant's guilt or innocence of facilitation of attempted first-degree murder, which is a lesser included offense. Lesser included offenses as to count 3, facilitation of a felony. For you to find a defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant knew that another person intended to commit the specific offense, but did not have the intent to promote or assist the commission of the offense or to benefit in the proceeds or results of the offense. And 2, that the defendant furnished substantial assistance to that person in the commission of the offense. And 3, that the defendant furnished such assistance knowingly. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. The definition of intentionally and knowingly as applied to this instruction have been previously explained to you. Facilitation to commit a felony as to count 3 of this instruction applies to the offenses of attempted first-degree murder, attempted second-degree murder, attempted aggravated assault, attempted voluntary manslaughter, and attempted reckless endangerment. What in law it takes to constitute each of these offenses and the definitions related thereto are explained to you in these instructions. Criminal attempt. For you to find a person guilty of criminal attempt, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant intended to commit the specific offense of second-degree murder, aggravated assault, voluntary manslaughter, or reckless endangerment. And 2, that the defendant did some act intending to complete a course of action or cause a result that would constitute the offense under the circumstances as the defendant believed them to be at the time, and his actions constituted a substantial step towards the commission of the offense. The defendant's actions do not constitute a substantial step unless the defendant's entire course of action clearly shows his intent to commit the offense. Intending means that a person acts intentionally when it is the person's conscious objective or desire to cause the death of the alleged victim. The essential elements necessary to constitute second-degree murder the essential elements necessary to constitute second-degree murder are that the defendant unlawfully kill the alleged victim and that the defendant act knowingly. The essential elements necessary to constitute voluntary manslaughter are that the defendant unlawfully kill the alleged victim, that the defendant act intentionally or knowingly, and that the killing results from a state of passion produced by adequate provocation sufficient to lead a reasonable person to act in an irrational manner. The distinction between voluntary manslaughter and second-degree murder is that voluntary manslaughter requires that the killing result from a state of passion produced by adequate provocation sufficient to lead a reasonable person to act in an irrational manner. The essential elements necessary to constitute aggravated assault are that the defendant intentionally or knowingly caused bodily injury to another, and that the defendant let's read that paragraph over. The essential elements necessary to constitute aggravated assault are that the defendant intentionally or knowingly caused bodily injury to another, and that the act resulted in serious bodily injury. The essential elements necessary to constitute reckless endangerment are that the defendant engaged in conduct which placed or might have placed another person in imminent danger of death or serious bodily injury, that the defendant acted recklessly, and that the offense was committed with a deadly weapon. Deadly weapon means a firearm or anything manifestly designed, made, or adapted for the purpose of inflicting death or serious bodily injury, or anything that in the manner of its use or intended use is capable of causing death or serious bodily injury. The definitions of knowingly and intentionally as applied to this instruction have been previously explained to you. Count 4, assault. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant caused bodily injury to another, and 2, that the defendant acted either intentionally, knowingly, or recklessly. Bodily injury includes a cut, abrasion, bruise, burn, or disfigurement, and physical pain or temporary illness or impairment of the function of a bodily member, organ, or mental faculty. The definitions of intentionally, knowingly, and recklessly as applied to this instruction have been previously explained to you. If you find from the proof beyond a reasonable doubt that the defendant is guilty of assault as charged in count 4 of the indictment, you will so report by use of the verdict form that will be provided for you. The court will thereafter set the punishment after a separate sentencing hearing. If you find the defendant not guilty of assault, or if you have a reasonable doubt as to his guilt of this offense, then at that event, you must acquit him of this offense and next consider the defendant's guilt or innocence of attempted assault, which is a lesser included offense. Lesser included offense as to count 4, criminal attempt. For you to find a person guilty of criminal attempt, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant intended to commit the specific offense, and 2, that the defendant did some act intended to complete a course of action or cause a result that would constitute the offense under the circumstances as the defendant believed them to be at the time, and his actions constituted a substantial step towards the commission of the offense. The defendant's actions do not constitute a substantial step unless the defendant's entire course of action clearly shows his intent to commit the offense. Sometimes in the trial of a criminal case, when a defendant is charged with a crime, this crime includes lesser included offenses. The law permits the jury to find the accused guilty of a lesser included offense, which is included in the crime charged in the indictment, whenever such course is consistent with the facts found by the jury from the evidence in the case, and when the law is given in the instructions of the court. If you find the defendant guilty of a lesser included offense, the court will thereafter set the punishment after a separate sentencing hearing. When you begin your deliberations, you must first deliberate on the indicted or charged offense. If you find the defendant guilty of the indicted offense, you may stop your deliberations. If you find the defendant not guilty of the indicted offense, or if you have a reasonable doubt as to the defendant's guilt, then you must find the defendant not guilty of the indicted offense and next consider the lesser included offenses. Should you convict the defendant of any of the offenses heretofore defined and explained to you, it would be your duty to state in your verdict of what offense you found the defendant guilty. The court thereafter will set the punishment after a separate sentencing hearing. The crime charged in each count of the indictment is a separate and distinct offense. You must decide each charge separately on the evidence and the law applicable to it. The defendant may be found guilty or not guilty of any or all of the offenses charged. Your finding as to each crime charged must be stated in your verdict. Members of the jury, I notice that some of the jurors appear to be making notes during the trial of this case. Please bear in mind that these are your notes and for your use alone. The taking of notes is simply an aid to memory, and the jury must understand that they are to recall the testimony and use the notes only as an aid to memory, and any juror who takes notes will use those notes only for that juror's assistance and in that regard, and not as an authoritative thing to show other jurors. During the trial, you heard the expert testimony of Dr. Gulpreet Bowman, who was described to us as an expert in the field of forensic science, and Benjamin LeBlanc, who was described to us as an expert in the field of forensic biology. The rules of evidence provide that if scientific, technical, or other specialized knowledge might assist the jury in understanding the evidence or in determining a fact in issue, a witness qualified as an expert by reason of special knowledge, skill, or experience may testify and state his or her opinions concerning such matters and give reasons for his or her testimony. Merely because an expert witness has expressed an opinion does not mean, however, that you are bound to accept this opinion. The same as with any other witness, it is up to you to decide whether you believe this testimony or choose to rely upon it. Part of that decision will depend on your judgment about whether the witness's background or training and experience is sufficient for the witness to give the expert opinion that you heard. You must also decide whether the witness's opinions are based on sound reasons, judgment, and information. You are to give the testimony of an expert such weight and value as you think it deserves, along with all the other evidence in the case. The flight of a person accused of a crime is a circumstance which, when considered with all of the facts of the case, may justify an inference of guilt. Flight is the voluntary withdrawal of oneself for the purpose of evading arrest or prosecution for the crime charge. Whether the evidence presented proves beyond a reasonable doubt that the defendant fled is a question for your determination. The law makes no precise distinction as to the manner or method of flight. It may be open, or it may be hurried or concealed. It may be a hurried or concealed departure, or it may be a concealment within the jurisdiction. However, it takes both the leaving the scene of the difficulty and a subsequent hiding out, evasion, or concealment in the community, or a leaving of the community for parts unknown to constitute flight. If flight is proved, the fact of flight alone does not allow you to find that the defendant is guilty of the crime alleged. However, since flight by a defendant may be caused by a consciousness of guilt, you may consider the fact of flight, if flight is so proven, together with all of the other evidence when you decide the guilt or innocence of the defendant. On the other hand, an entirely innocent person may take flight, and such flight may be explained by the proof offered or by the facts and circumstances of the case. Whether there was flight by the defendant, the reasons for it, and the weight to be given to it are questions for you to determine. Included in the defendant's plea of not guilty is his plea of defense of a third person. A person is justified in threatening or using force against another person to protect a third person if, under the circumstances as the person reasonably believes them to be, the person will be justified under the principles which apply to self-defense and threatening or using force to protect against the use or attempted use of unlawful force reasonably believed to be threatening the third person sought to be protected, and two, that the person reasonably believes that the intervention is immediately necessary to protect the third person. The burden is on the state to prove beyond a reasonable doubt that the defendant did not act in the defense of a third person. If from all the facts and circumstances you find the defendant acted in the defense of a third person, or if you have a reasonable doubt as to whether the defendant acted in the defense of a third person, you must find him not guilty. Included in the defendant's plea of not guilty is his plea of self-defense. If a defendant was in a place where he or she had a right to be, he or she would have a right to threaten or use force against the deceased when and to the degree the defendant reasonably believed the force was immediately necessary to protect against the alleged victim's use or attempted use of unlawful force. In determining whether the defendant's threat or use of force in defending himself was reasonable, you may consider not only his threat or use of force, but also all the facts and circumstances surrounding and leading up to it. Factors to consider in deciding whether there was reasonable grounds for the defendant to fear death or serious bodily injury from the deceased include, but are not limited to, any previous threats of the deceased made known to the defendant, the character of the deceased for violence when known to the defendant, the animosity of the deceased for the defendant as revealed by the defendant by previous acts and words of the deceased, and the manner in which the parties were armed in their relative strengths and sizes. The threat or use of force against the deceased would not have been justified if the defendant provoked the deceased's use or attempted use of unlawful force unless the defendant abandoned the encounter or clearly communicated to the deceased the intent to do so, and the deceased nevertheless continued to use unlawful force against the defendant. Force means compulsion by the use of physical power or violence. Violence means evidence of physical force unlawfully exercised so as to damage, injure, or abuse. Physical contact is not required to prove violence. Imminent means near at hand, on the point of happening. Serious bodily injury means bodily injury that involves a substantial risk of death, protracted unconsciousness, extreme physical pain, protracted or obvious disfigurement, or protracted loss or substantial impairment of a function of a bodily member, organ, or mental faculty. The burden is on the state to prove beyond a reasonable doubt that the defendant did not act in self-defense. To convict the defendant, the state must prove beyond a reasonable doubt that the defendant did not act in self-defense. If from all the facts and circumstances you find the defendant acted in self-defense, or if you have a reasonable doubt as to whether the defendant acted in self-defense, you must find him not guilty. The guilt of the defendant, as well as any fact required to be proved, may be established by direct evidence, circumstantial evidence, or by both. Direct evidence is defined as evidence that proves the existence of the fact in issue without inference or presumption. Direct evidence may consist of testimony of a person who has perceived by the means of his or her senses the existence of a fact sought to be proved or disproved. Circumstantial evidence consists of proof of collateral facts and circumstances which do not directly prove the fact in issue, but from which that fact may be logically inferred. It is your duty to decide how much weight to give the direct and circumstantial evidence. The law makes no distinction between the weight that you should give to either one, or say that one is any better evidence than the other. You should consider all evidence, both direct and circumstantial, and give it whatever weight you believe it deserves. You are the exclusive judges of the credibility of the witnesses and the weight to be given to their testimony. If there are conflicts in the testimony of the different witnesses, you must reconcile them if you can without hastily or rashly concluding that any witness has sworn falsely, for the law presumes that all witnesses are truthful. In forming your opinion as to the credibility of a witness, you may look to the proof, if any, of his or her general character, the evidence, if any, of the witness's reputation for truth and veracity, the intelligence and respectability of the witness, his or her interest or lack of interest in the outcome of the trial, his or her feelings, his or her apparent fairness or bias, his or her means of knowledge, the reasonableness of his or her statements, his or her appearance and demeanor while testifying, his or her contradictory statements as to material matters, if any are shown, and all the evidence in the case tending to corroborate or to contradict him or her. A witness may be impeached by proving that he or she has made some material statements out of court which are at variance with his or her evidence on the witness stand. However, proof of such prior inconsistent statements may be considered by you only for the purpose of testing the witness's credibility and not as substantive evidence of the truth of the matter asserted in such out-of-court statements. Further, a witness may be impeached by a careful cross-examination involving the witness in contradictory, unreasonable, and improbable statements. However, immaterial discrepancies or differences in the statements of witnesses do not affect their credibility unless it should plainly appear that some witness has willfully testified falsely. When a witness is thus impeached, the jury has the right to disregard his or her evidence and treat it as untrue, except where it is corroborated by other credible testimony or by the facts and circumstances proved at trial. The defendant has not taken the stand to testify as a witness, but you should place no significance on this fact. The defendant is presumed innocent, and the burden is on the state to prove his or her guilt beyond a reasonable doubt. He or she is not required to take the stand in their own defense, and their election to not do so cannot be considered for any purpose against him, nor can any inference be drawn from such fact. The court charges you that the defendant's identity must be proven in this case on the part of the state to your satisfaction beyond a reasonable doubt. In other words, the burden of proof is on the state to show that the defendant now on trial before you is the identical person who committed the alleged crime with which he is charged. In considering the identity of a person, the jury may take into consideration all of the facts and circumstances in the case. The court further charges you that if you are satisfied from the whole proof in the case beyond a reasonable doubt that the defendant Michael David Moseley committed the crime charged against him, and you are satisfied beyond a reasonable doubt that the defendant has been identified as the person who committed the crime charge, then it would be your duty to convict him. On the other hand,
Yeah, that was Channel 4 cutting the feed short, guys. That's it. So we're done. Waiting to see what's going to happen. It's out of everybody's hands. The world holds its breath and waits. Just checking the poll results. Okay, 87% guilty. Yeah, I think he's guilty. If he's not convicted on everything, I'm very surprised. I don't think he has any justification for any of the uses of force he did. Yeah, so this is verdict watch mode. I will say, and I really only have one comment right now, and I'm gonna probably lay back down after this. That closing by the prosecution was not the best, especially the rebuttal. In the rebuttal, they touched on a bunch of stuff they should have touched on at the beginning, like the fact circumstantial evidence of guilt that he fled, the self-defense for the duty to retreat, that he had multiple opportunities to leave and he didn't leave, that he got thrown out of the fight and then he ran back into the fight. They didn't. That was not covered very well. And if the defense doesn't cover it, you can't talk about it on rebuttal. It's very much like cross-examination in a way. So they left a lot on the table. I think that was very poor overall. I just think they could have done that a lot better. I'd give that like a D. That was really bad. It's thankfully they have a really strong case. Shah, I just think I heard a porta potty door shut in the courtroom. So yeah, that's it, guys. I just don't think it was very, very good overall. I will try to send a Jackie, yeah, everybody here. I will try to send out a reminder on the community when the verdict's coming back. I don't think they're going to be gone longer than 90 minutes. This is going to be very short. I mean, they'll take their time getting a free lunch, but I don't think they're going to be wasting too much time on this. So what's very interesting? I'm feeling better, so we will do the Thursday night show tonight, guys. A lot to talk about. But yeah, that's it. I think this case is pretty straightforward. This was a guy who, and I think the defense did a good job with what they had, but they don't have much to work with. So, for the prosecution side, this was a pretty good case. I just think the prosecution did a shitty closing. The closing and then the rebuttal were just not very good, but thankfully their case bails them out. Yeah, for right now we're going to be ending it. I'll let it run for a while if you guys want. If you want me to leave it on, Shannon, I can leave it on for now and we can come back to it. But actually, you know what? I'll end this one, then I'll restart one for the verdict. How about that, you guys? How about we do it that way? All right. Well, I'm glad it sounds good to you guys because that's what I'm going to do anyway. No, Matthew, my over-under is 90 minutes. I take the under. I will give you over. So it's not double already because I already lost once. I lost twice. So I got to take my chance. So, all right, guys. Well, I'm going to hang this up and we'll restart the next one. Hold tight.